All persons that have business before the honorable of the judges, now understand that this appeal right here and give your attention. So I think the United States and it's on the court. This on the court is now in session. Please be seated and come forward.
Thank you. Good morning. We have 3 cases on the calendar this morning, and we'll take them in the order in which they appear. First case is CORCORAN Gallery of Art versus Suzanne Jill Petty.
Good morning, Your Honors. May it please the court. I'm Charles Patrizzi of the Paul Hastings firm representing the CORCORAN Gallery. I would ask the court's indulgence to reserve 5 minutes of my time for rebuttal. The principal issue before the court this morning is whether the California probate court had personal jurisdiction before it issued a default in the original proceeding. The law in this court is quite clear, as it is generally universal, that this court must determine de novo, as the court below must have determined de novo, whether or not personal jurisdiction existed at the time that the default was issued.
I would understand that to be de novo if we didn't have the benefit of the California Court of Appeals decision, which I understand also is entitled to full faith and credit.
Well, there's 2 answers to that, Your Honor. The first one is that the law is that the proceeding here is de novo on the issue of jurisdiction. It must look at California law. California law governs in that sense. But the California Court of Appeals determination is not entitled to full faith and credit or collateral estoppel. Number one, the record before that court is not filed in this court. There's no basis on which this court can make the determination of what issues were litigated there. But in any event,
we can't look at its opinion. We have the opinion. We see which issues were litigated there. It's in the record. It lays out that this jurisdiction at some length, the jurisdictional issue that was under consideration. Why isn't that enough?
Because this court has to determine de novo whether or not, in fact, personal jurisdiction existed, whether or not the California Court of Appeals made that determination.
Where do you get that from?
From Durfee.
Durfee did not involve a case where somebody appealed the original court's action to their own state's court of appeal. And then there is now an appellate court judgment that jurisdiction was proper. What case do you have that says, even when that happens, even when an initial exercise of jurisdiction is appealed up in that same court system, and it's affirmed that jurisdiction exists, that I take it you think every subsequent, if A, do you have a case? And B, imagine these Pascal works were scattered across 50 different states. Do you think every single one of those states in an enforcement action has to exercise its independent judgment as to whether or not California's judgment was correct on jurisdictional grounds?
I think as a matter of due process, this court must make the determination on its own, de novo.
So first step is what's your case?
I think Tom Brown stands for that proposition.
Tom Brown, you think is a case where there's an exercise of jurisdiction that was appealed up to an appellate court in the same system, and then a foreign jurisdiction said, I'll go look at it, but I just want to understand that this is your understanding of Tom Brown. Another jurisdiction said, despite that appellate court's agreement, we look at this and we disagree.
That is, well, I want to be clear, Your Honor. In Tom Brown, full faith and credit was granted after this court made the de novo determination. But that case, Tom Brown sets the standard on which this court needs to proceed.
What about the Verone case, Verone versus Verone, where jurisdiction was successfully litigated elsewhere, and that was sufficient for our purposes to determine the jurisdictional issue for ourselves?
It was sufficient for you to determine the issue for yourselves. Again, the point, Your Honor, is that this court must make its own determination on the jurisdictional issue.
And so if we determine that the California court, through full and fair litigation, decided the jurisdictional issue, you agree that's the end of the matter for us?
I would not agree, Your Honor, because there is an underlying due process issue. What the California Court of Appeals did, I think, has to be looked at in 2 regards. First, the California Court of Appeals had what is frankly, as Judge Deal said, a very lengthy opinion. But in that case, it made 2 determinations with regard to jurisdiction. on alternative grounds. So it's not clear what grounds it actually relied upon. It indicated on the one hand that the subsequent motion for reconsideration was a general appearance. And second, made the determination that in any event, that motion for reconsideration was in its view, quote, not legitimate, close quote, despite the fact that California law and the Obrecht decision said that's exactly what someone should do in that instance. Because those were alternative grounds, it's not clear what was necessary for the decision. But in any event, the California court's determination that a motion for reconsideration filed subsequent to a default is a retroactive recognition of personal jurisdiction is flatly wrong. The
If
object.
it's flatly wrong, isn't that an issue you take to the California Court of Appeal, which you lost? And then that determination gets collateral estoppel effect here.
Well, there's two problems with that, Your Honor. The first one is that there was no determination in the probate court that the motion for reconsideration was a general appearance. The court in the probate court never considered the issue at all. It simply ignored the motion.
And that's why you took an appeal.
We did take an appeal on that basis, but the California Court of Appeals then made the determination that that was a retroactive recognition of personal jurisdiction.
I don't know why you refer to it as a retroactive recognition. I mean, I think it's, some confirmation that personal jurisdiction existed all along. Your attorney showed up at a status hearing without objecting to jurisdiction in June. And so I don't see what's retroactive about it. I mean, what I see is a California court, after full opportunity on briefing, has decided that they had jurisdiction in the Court of Appeals. And I just want to ask what sense your alternative view makes. Can I ask, if this had been a little bit different and the probate court said, I don't have jurisdiction, case dismissed, and then it was the trustee who appealed to the California Court of Appeals and said, actually, you did have jurisdiction, case reinstated, take it back, probate court. And the probate court says, well, I thought, frankly, our judgment is we don't have jurisdiction, but I guess we have to proceed because the Court of Appeals says so. If then there is a judgment in our court, what result? Do we look at the California Superior Court's, the trial court's decision that it doesn't have jurisdiction, and do we give that full faith and credit? Or do you kind of say, well, at the end of the day, the appellate court is the final authority. They say there is jurisdiction, and that's what we give full faith and credit to. How do you think it should work?
Well, there's two answers to that, Your Honor. The first one is that this court has to make its own decision, its own de novo determination of whether jurisdiction exists.
Yeah, that's
Your Honor's
definitely
question-
false. That's definitely false under the full faith and credit clause. We give full faith and credit to other courts' jurisdictional determinations.
You give full faith and credit to a jurisdictional determination if it has been fully and fairly
Correct.
litigated. The only way you could determine whether or not it was fully and fairly litigated is if the entire record is before Your Honor, and it is not.
I don't know why I can't determine it from the face of the California Court of Appeals opinion. They thought through this exhaustively. How much more do I need? Like a 37-page opinion isn't good enough?
I would not say it is exhaustive. It is long, but it goes through a number of issues. And frankly, as I said to Judge Ali Khan, the difficulty is that there are alternative grounds in that decision. You could give full faith and credit to a determination which is necessary for the ultimate determination of jurisdiction. They had alternative grounds. And if
You can have alternative grounds for holdings. I mean, you say it's not clear which one controls. As I read the opinion, it's both. We think for both reasons there's jurisdiction. You want to point me to something in that opinion that suggests they were wishy-washy on one or the other? It's well established that courts can issue alternative grounds for their holdings.
It is well established that courts can have alternative grounds, but this court must then make the determination of what the necessary grounds were. If, as the Court of Appeals said, the motion for reconsideration was, quote, not legitimate, beside the Obrecht holding, which is that was the way to proceed in California, then that motion for reconsideration is never before this court. The Tom Brown case establishes that if that motion was not considered, this court must make the determination of the original jurisdiction in the probate court de novo. And the motion for reconsideration wipes away. It is simply not relevant to the determination of jurisdiction.
And
in this court.
if we agree with you and we say, okay, there was no jurisdiction, and it turns out that some of these works are also in Maryland and there's another enforcement action there, should they give our judgment full faith and credit, or do they look to the California probate court and give that de novo review? And does that happen 50 times in 50 states if the works are scattered?
Well, I mean, the first answer to that question is the works were not scattered. So that.
I know,
issue
that's
will
why
not
it's a
arise.
hypothetical,
So
yeah.
putting aside the difficulty with the hypothetical.
It's not a difficulty with the hypothetical, it's just a hypothetical. I understand it's a counterfactual.
Putting aside the counterfactual hypothetical and giving your honor that view, the issue would be whether or not full faith and credit is given not simply to this court's determination not to enforce the California probate judgment, because that's all that this court determines. It doesn't determine the validity in any sense other than that this court will not permit the enforcement. It will not give it full faith and credit. There certainly are cases, and we've cited some in the brief.
Just so I can get a bottom line answer, is your bottom line answer, yes, that would be litigated 50 different times?
It would be litigated wherever the issue would arise.
Does that seem like a sensible way of litigating cases or a sensible reading of the full faith and credit clause to you?
No, but the reason for that is that the California court didn't give full faith and credit to the Cypre determination already made in this court. Once that Cypre decision was made, it is entitled to full faith and credit. The California court did not give it any credit at all. And on that basis, the hypothetical simply fails because there would not be 50 determinations. There would only have to be a determination of the validity of the Cypre order and its effect on all of the works possessed by the Corcoran at the time of the Cypre issue.
The California Court of Appeals did address that question. It found that there was no full faith and credit issue because both the California probate court order and the Cypre order could be enforced. There was no conflict.
The problem, Your Honor, is that by the very action of doing that, the California court did not give any credence to the Cypre order and its effect on the Pascal works. The California Court of Appeals determination that there's no conflict is completely without any basis in the record. There simply is no record, A, before this court, but B, there was no record before the California court as to the determination of the Cypre order and its effect.
I mean, what
on the
record did
Pascal works.
it need? It had the Cypre order before it, and it had the California probate court order before it, and it read them to see if there was a conflict and said there wasn't one.
If the California probate court order was issued on default, there was no record before the California probate court on which the
Sure. The
determination was
question
made.
is default or not, whether the two orders the court has before them conflict.
But there has to be a record on which there is a determination of the scope of the Cypre order. There was no record before the probate court and therefore no record before the California Court of Appeals. On which to
So
make
you're
it.
saying that the California Court of Appeals is not entitled to read the Cypre order and determine its scope?
It is certainly entitled to read the Cypre order. In determining the scope of that order, it has to have a full record on what that determination was and what was before the court in doing so.
What more would need to be in the record?
There would need to be a record about what the Cypre order affected, what works were affected by it. The California Court of Appeals, in reading the Cypre order, put a gloss on the determination of the Cypre court that all instruments that needed to be revised in order to permit the implementation of the Cypre order were appropriately revised. The instruments that are affected are not simply the instruments in relation to the National Gallery and GW, which is what the Court of Appeals in California held, because the California court ignored the fact that all of the works that the Corcoran possessed are being subject to the process determined by the Cypre order. For the court's indulgence, there were some 18,000 works possessed by the Corcoran. Of those 18,000 works, some 1,700 were not fully implemented in the permanent collection, but they were held by the court. They were possessed and held title by the court. Those works are subject to the Cypre order. If they were not, if anybody could come in and say, well, my works aren't subject to the order, then the implementation of the Cypre order becomes impossible.
It doesn't seem like the court was saying that they're not subject to the Cypre order. It's saying the Cypre order did not modify the requirements of the 1994 order requiring that these works be displayed. And given that they were not going to be displayed, then they should, then there's a violation of the 1994 order or agreement.
Whether or not there was a breach of the 1994 agreement is a factual issue that was not determined. There's only a default. There's no record showing that there was in fact a breach. But beyond that, Your
Do
Honor,
you
again, the
think, as
point
you
is,
stand here today, that the CORCORAN or the National Gallery or GW is displaying these works in accordance with the 1994 agreement? It's my understanding no one disputes they're sitting in storage.
they are in storage because the Corcoran Gallery was undergoing reconstruction. It was part of the necessary work which is described in the cypre. The gallery exists, the name exists on the gallery, the works are in the possession and storage and can be displayed if that were determined to be the appropriate result. The gallery still exists, the shelves still exist, the work still exists. And in fact, there are other works that were under the cypre order that are being exhibited and are part of the gallery building still.
Well, and perhaps the original owners of those could seek to have them back.
But that exactly establishes the problem, Your Honor. If the cypre order is subject to subsequent collateral attack repeatedly because someone asserts that their works are not within that cypre order, the cypre order loses all finality, the ability of the court.
Where are you saying that they're not within the cypre order? My understanding is that the cypre order did not invalidate the requirements of the 1994 agreement. And I think you seem to be taking the position that once the cypre order is in place, it just washes away every prior commitment.
It does not wash away the prior commitments. By the very terms of the cypre order, those agreements are revised to the extent necessary to implement the cypre order.
And so what was the revision that happened to the 1994 agreement that means that you don't have to return these when they're not on display per the terms of the agreement?
The revision is that these works will be subject to display in a different location in the District of Columbia in accordance with the cypre determination as to which gallery within the District of Columbia would have those works. If they are to move outside of the District of Columbia, then either the Attorney General has to agree or we go back to the Superior Court. The determination from the process under the cypre order was that these works would be given to a gallery at American University and would be displayed at the gallery in the American University and would be subject to the other conditions, which include the availability for study and for other purposes. I see I'm out of time. I'm happy to respond to any additional questions the court has.
Well, we'll give you a few minutes in rebuttal. Let us hear from your adversary.
Thank you, Your Honor.
Good morning, may it please the court. My name is Hannah Wicker and I represent Suzanne Jill Petty, the trustee of the Alice C. Tyler Trust. If full faith and credit means anything, it has to mean this. A party cannot come and seek the exact same relief with the exact same facts and the exact same law in 4 different courts and then come to a 5th court and ask that court to finally rule in its favor. As Your Honor said, if that were the case, that would open the DC Court of Appeal to needless collateral attack on almost every judgment in a foreign jurisdiction, and that would make absolutely no sense. Now, this case is very simple.
If CORCORAN had not appealed to the California Appellate Court, they could have challenged the jurisdiction of the probate court in the DC courts?
No, this was still properly a case that was in California. It's what they should have done. If they truly believed that there was no jurisdiction, they should have stopped there, waited for judgment enforcement in DC, and then brought this proceeding in DC. But this case was still properly before the California courts and properly appealed to the California Court of Appeals and to the California Supreme Court, all of which the CORCORAN did here. And that's where this case was properly decided. The only issue in front of this appellate, in front of you, is whether this case was fully and fairly litigated in California. The record is very clear that this case was fully and fairly litigated, both in the California Probate Court and in the California Court of Appeals.
Do you think we need to decide the first thing, whether or not it was fully and fairly litigated in the California Probate Court?
I think it is relevant to, I think you need to decide if it was fully and fairly litigated in California. And the answer to that is yes. So no, you're not limited just to the California Probate Court. You can and should consider the California Court of Appeals judgment.
And then I have a case question. So I asked appellant whether or not there was a case where somebody had really tried to challenge an underlying judgment when they had already appealed it within the other court's internal structure. And he points me to Tom Brown. When I look at Tom Brown, I don't think it is that kind of case. There's no indication that there is an appeal to the main appellate courts. So it looks to be a case where the person who then brought a case here had never fully and fairly litigated the thing up to an appellate court. So, but let me ask you if you have a case, which is, do you have a case? Because I wasn't able to find one where somebody that arises in this posture, where let me posit that the California probate court was wrong. It did not have jurisdiction. But then it's litigated to the California Court of Appeals. When I say posit, let me say that that's my view. Hypothetically, my view is the California probate court was wrong. But the California Court of Appeals has already opined on that and said, no, it did have jurisdiction. Do you have a case that looks like that, where the court originally exercising jurisdiction says one thing, there is an appeal within that system, and then a foreign jurisdiction takes the case and opines either we need to assess the original court's jurisdiction or not, versus just looking at the appellate decision and saying, well, that's what we're going to give full faith and credit to. Do you have a case like that?
No case comes to mind, Your Honor. And I think that that's part of the problem of this case, really. Because if you take the CORCORAN's view and you say that you can only look at full faith and credit of, say, the trial court, and then the appellate court goes the other way, that presents an issue for every jurisdiction thereafter. Which one do you give full faith and credit to? And obviously, you need to give full faith and credit to the final judgment of the foreign jurisdiction. So if the appellate court reverses, you need to give that full faith and credit and not say, well, we're going to set that aside and go back to the trial court. And that's one of the reasons that full faith and credit applies to appellate bodies, to the entire proceedings of the state, which is what the Fourth Amendment says, and not just to the trial court. And that's why this court can and should look at the decision of the California Court of Appeals, where, as your honors have referenced several times, the CORCORAN raised every single issue it has tried to raise in this proceeding. It got a ruling on every single issue it has tried to raise in front of the DC Superior Court and the DC body. And that should be the end of it.
I take your point that we should give full faith and credit, to the extent applicable, to the decision of the California Court of Appeals. How do you respond to Mr. Patrizio's argument that the California Court of Appeals didn't clearly make a decision? In effect, this is what he's saying, didn't really clearly make a decision to which we can give full faith and credit to, because it came out with alternative holdings and you don't know which one is the one that we can give full faith and credit to. And if we give full faith and credit to one of them, it might not get you where you want to go.
I think that you can give full faith and credit to the judgment of the California courts. And the judgment of the California courts is that the petition in this case was affirmed. As your honors have noted, courts can give alternative holdings, but the point is that the California court held that the petition in this case is what it is, and that the artwork should be returned to the trust. That is the judgment you should give full faith and credit to. I don't think you need to parse through the California court's ruling and say they were correct on this topic and maybe not correct on this topic.
Suppose the California, no, here we're getting into a bit of a hypothetical, I guess, and I distrust them, but suppose the California Court of Appeals simply affirmed, but failed to grapple with in any intelligible way the question of whether the probate court properly exercised jurisdiction.
It doesn't matter. California judgments are entitled to full faith and credit if it was fully litigated below. There's ample evidence that it was fully litigated below, that the probate court had the CORCORAN's arguments and facts in front of it, and that the Court of Appeals did too. That's enough. That's full faith and credit. And that's where this case should end.
And what do you make of your friend on the other side's point that there wasn't a fulsome record before the California Court of Appeal on whether the cypre and the probate court's orders could live in harmony?
Well, I think that your honor is exactly right when you were discussing this. First of all, the record on appeal is the responsibility of the appellant. So if there was more on appeal that they want to put into the record, that's their responsibility, and the judgments below are presumed correct. But I think if you look at the California court's order, it did consider the cypre order and it made a ruling. The CORCORAN may not like that ruling, but the court definitely treated with the issue, and that is entitled to full faith and credit as well. If your honors have any questions about what was in front of the probate court or about jurisdiction, I am happy to answer them. Otherwise, I will just say that judgments of foreign jurisdictions are entitled to full faith and credit for a reason. And that reason is that there has to be an end to litigation, and we cannot have conflicting rulings from conflicting jurisdictions on every single issue.
I do have one last question,
Yes.
which I realize might actually not entirely be for you. Assuming that you prevail here, what are the kind of next steps? I do understand that the cypre requires, the input of the Attorney General and some other kinds of protocol. So how does that kind of work with the two judgments that you have?
Yes, and this is in the record. We will continue to enforce this judgment as we have done for years now. And we will get the artwork returned to us and seek return of the cash gift. I believe in the record, there's at least a statement from opposing counsel saying he spoke to the Attorney General and he is not going to contest the art moving back to California in accordance with the 1994 agreement. And the parties have actually already selected the organizations to which that art is going to go.
So in your view, anything that needs to happen under the cypre to the extent it applies has been completed.
In my view, and based on the correspondence we've received to counsel in the record, everyone's view.
Thanks.
I take it you're also seeking a damages award of or maybe it's restitution of $1 million.
We're seeking under the contract, the return of the $1 million gift in accordance with the contract because of the breach and in accordance with the California court's orders.
And do I remember correctly that the California Court of Appeals addressed the argument of whether or not it needed to give full faith and credit to the cypre action in the DC Superior Court? It did, am I right?
Yes, they did.
And isn't it a little bit weird then to say, well, we owe their judgment about that full faith and credit? Because then it just seems like the worst actor, the court that is willing to, like, if they're wrong about that, can't we consider that?
No, it's not a circle of full faith and credit. What they said was that the cypre order doesn't apply to the artwork in question here. And then they set forth their reasoning. That's entitled to full faith and credit.
I mean, and even if it were squarely against prior, DC precedent as the later in time judgment, it would control, correct?
Yes. And there's no evidence it is against DC judgment. In fact, there's also a letter in the record from the cypre judge saying this artwork is not covered by the cypre order.
And am I correct that our court has never actually taken a position on this, order of operations question?
On the order of operation.
Like, if there's the first judgment goes one way, the second goes another, who gets, what effect the third court does?
I don't have a case off the top of my head. I know in other jurisdictions it has been.
Okay. Yeah, I think that seems to be the majority rule of the latest in time controls. I just didn't think our court had addressed it before.
Which also makes a lot of sense in the context of full faith and credit, because as you were saying earlier, if you do have courts making different rulings at different times, the first one needs control, otherwise it will just be chaos.
No, I mean, I don't think it makes much sense at all. If court A resolves an issue squarely, and then court B says, we don't like the way they resolved that, so we're going to resolve it the other way. Court A then owes full faith and credit to that as the last in time. You think that's a sensible rule? I would think it makes more sense to, if you actually find a square conflict between the two, the earlier of the two judgments ought to control. I mean, maybe I'm misunderstanding the proposition.
That's what I was trying to say. Yes, the first
Okay.
judgment should control.
Okay.
Yes.
Okay.
If your honors have no further questions, thank you for your time and consideration.
Thank you. Mr. Petrucci, we'll give you a few minutes in rebuttal.
Thank you, Your Honor.
I apologize to Judge Deal. I went back and looked at Tom Brown, and you are correct. Tom Brown does not involve an appeal. It was an order from the trial court level, and I apologize to the court. My memory
problem.
was wrong.
It's tough being on your feet. I have a whole computer in front of me.
Memory is what it is, Judge, and I apologize. But in any event, I think there's a couple of points to make. The first one is that counsel, my good friend, argued that there was full and fair litigation in the probate court in California. There was no litigation in the probate court in California. There was an appearance in June in which the only statement was we would have objections if and when properly served. That's not a general appearance, and it certainly is not full and fair litigation. There was no appearance at the subsequent July hearing. There's no full and fair litigation. The motion for reconsideration was filed, but was ignored by the probate court. So there is no full and fair litigation in the probate court at all. And that is simply wrong. To the degree there is an assertion that there was full and fair litigation in the California Court of Appeals, and that is somehow collateral estoppel on this court, the answer to that, it is their burden in trying to make the collateral estoppel argument to put the record before the court, and they have not done so. Second, I think it's important to note that the California Court of Appeals, and I think it's footnote 16, and I will refer to that in the record, goes through a rather lengthy footnote about an assertion that the motion for reconsideration was not legitimate, that it in effect doubly waived certain issues. But the core of that issue is a retroactive application asserting that the motion for reconsideration is a general appearance and that that general appearance operates retroactively to justify the probate court issuing a default. That cannot be the case. First of all, Tom Brown makes clear to this court that where the motion for reconsideration was never considered, it simply is dropped from the record. It cannot be the assertion of general appearance. But second,
But that seems to be a question of California procedure that the California court decided against you. And so it strikes me as odd that we would come in and say, as a matter of California civil procedure, this is how things should operate when they've told us that's not.
well, there's two answers to that, Your Honor. The first one is that this court must nonetheless make the determination de novo of whether there was jurisdiction in the probate court at the time that the probate court issued the default. As a matter of California procedure, California Court of Appeals, again, goes through this argument that the motion for reconsideration was not legitimate, that it was a waiver, that it was waived and couldn't be made, and also makes some determination about a retroactivity. If the footnote determination is the motion for reconsideration is never legitimate, then it could not be a general appearance and it could not operate retroactively at all. And that goes to the point. Judge
So,
Whitman
yeah,
made.
so let's say, again, to try to abstractify this. Let's say there is a very good argument that the probate court had no jurisdiction over the gallery. And let's posit that if there had been no further proceedings in California, and the case came up in this court, and the case came up in this court, the Superior Court here would not give full faith and credit to the probate court's decision.
Correct.
Okay, but instead, in this case, the gallery appealed to the Court of Appeals in California and said they had no jurisdiction over us. Or the probate court had no jurisdiction over us. Now, you're positing that the California Court of Appeals reached the wrong decision in disagreeing with the gallery. And you're positing they not only reached the wrong decision, but their reasoning was really very bad. And you're saying to us, we should look at that reasoning and see how bad it is and hold that there was no jurisdiction. That's basically what this comes down, and therefore we should not give full faith and credit, even though the decision of the probate court was affirmed by the California Court of Appeals. Now, is that within the scope, given that you had a full and fair opportunity to argue before the California Court of Appeals? Does it is it nonetheless within the scope of the Superior Court here to say, well, in my opinion, the California Court of Appeals got it egregiously wrong, and so I'm not going to give full faith and credit to the results of the California litigation? Is that within the scope of the full faith and credit doctrine?
I think it has to be, Your Honor. Especially given footnote 16 in their opinion, you don't know which basis. the
What is a
court
little
was
tricky
relying.
about that is that the case law seems to indicate that even if there's a good argument that the other court, the court in the foreign jurisdiction, got it wrong, you still give it, they're still entitled to full faith and credit. In other words, mere disagreement with the reasoning, the rationale given by the foreign jurisdiction is not quite enough to allow the Superior Court here
It
to
is not
deny
quite
full
enough,
faith and
so
credit.
long as this court can make the determination that there was full and fair litigation, the issues were all properly determined on a proper record. This court can't make that determination.
Well, when
And
you say
therefore, as a matter
properly
of due
determined on
process.
a proper record, you're saying something different from correctly, in our view, determined. I take it.
I agree with your honor that the case law, as I understand it, is that this court must make a de novo determination of jurisdiction. To the extent there has been a determination of jurisdiction in the court on which the judgment is being reviewed, had fully and fairly litigated the issue and on the basis of a full and fair record and full and fair litigation, made a jurisdictional determination, that might well stop this court from determining its own jurisdiction. But you have to make the full de novo determinations about the full and fair record, about the full and fair litigation, and make some determination that there was due process in the way in which that operated.
So
Otherwise,
in the
there's no
case here,
jurisdiction.
where the gallery had the opportunity to appeal to the Court of Appeals and make whatever arguments it sought to make, and move to amend the record as it saw fit, or expand the record as it saw fit. And the California Court of Appeals addressed the arguments and issued an opinion in which it sought to resolve them. And I think we have to say it's all good faith. There's no suggestion here that they were not acting in good faith. Does that end the inquiry?
I don't think
Even
so.
though we could say, gee, we look at their reasoning and we're not persuaded at all, in truth. Maybe that's true, but I'm not sure that that by itself gets you where you want to go. And I'm wondering if there's if you have some wrinkle on that takes it out of that, framework.
Well, I'm focusing on your honor's use of the term by itself. Because I think that your honor's hypothetical is that in effect, the issuance of an opinion by the California Court of Appeals after argument is at least demonstrative of full and fair litigation. And I don't think that's right. Your honor can't make that determination without knowing what the record was. And
Counsel,
without knowing,
Are you familiar with the Verone versus Verone case?
I have read it, your honor.
Okay.
I can't say that I am deeply steeped in it.
So it seems to me that is almost squarely on point here. It was a case where someone challenged the jurisdiction of a federal district court, took that up to the Court of Appeals, raised and argued the jurisdictional issues and lost. And when that came to us, we said that determination of jurisdiction was entitled to full faith and credit because the appellant there had presented his arguments in the other court. And that was the end of the matter. We didn't kind of peek behind the curtain about, how vigorously this was litigated or what the record before the federal appellate court had been. We said, you had the opportunity to challenge jurisdiction, you lost, and that's sufficient for us.
What I don't know about your honor, is the degree to which the record before this court at that time demonstrated full and fair opportunity to litigate in the trial court level and then at federal Court of Appeals. I simply don't know that, and it's not in the opinion, but I think the case law is that you have to look at that question. And that was my point, I think, to Judge Blakey.
It strikes me that if that were some independent requirement, we would see that in the opinion, and we don't.
I think we see it in the case law, your honor. I can't say we see it in the error opinion. Again, I'm out of time. If there are other questions, I'm happy to respond. I will just note one last point. It goes to Judge Deal's colloquy with my good friend. And that is, it must be the case, as my good friend has said, that it is the first judgment, which is entitled at bottom to full faith and credit. If it's the last judgment, as your honor suggested, then the court that is willing to ignore its full faith and credit obligations suddenly has overwhelming authority in its favor, and that cannot be the law. It has to be the law that it is the first judgment which is entitled to full faith and credit. I have nothing more unless the court has more questions.
Counsel, thank you both very much. The case is now submitted.
I thank your honors for your attention.
Call the second case on the calendar, United House of Prayer for All People of the Church of the Rock of the Apostolic Faith Incorporated versus Restoration Doctor LLC.
Good morning, Your Honors. Paul Schmidt from DLA Piper on behalf of the appellant, the United House of Prayer. The United House of Prayer, which is a nonprofit church that operates here in DC and in Baltimore, presently faces over $1.6 million of liability as a result of the trial court's flawed decision below. The church already paid over $500,000 for the work at issue. And the additional amount that the appellee seeks and was awarded by the Superior Court is almost double the value of what the building is presently worth. There's 5 issues on appeal, and I'll just run through them really quickly. First, the statute of limitations on this claim has run. RD Plural sought substitution. Excuse me, let me back up for a second. There's 2 entities that you'll be hearing a lot about today: Restoration Doctor LLC and Restoration Doctors LLC. Restoration Doctor LLC, undisputed, was the party to the original contract. Restoration Doctors LLC is the party that sought relief in the Superior Court and appears before you today. I'll refer to them as RD singular and RD plural to avoid any confusion. RD plural, the party that is before you today, sought substitution as the plaintiff 3.5 years after the contract claim at issue here began to accrue, well after the 3-year statute of limitations had expired. Rule 15C, which does allow for liberal relation back, that provision cannot save RD Plural's claim, as that rule does not apply when the original complaint was filed by a non-entity, another entity, Restoration Doctor Inc., which never existed, and therefore the original complaint was a nullity.
You know, you say the original complaint was filed by a non-entity. It would be more accurate to say it was filed in the name of a non-entity. And that makes a difference here, I think.
Well,
It's not as if there was nobody who filed it, you know, somebody filed that complaint. And the question is whether all we have here is simply a harmless misstatement of the name, akin to a typographical error, really.
well, it's certainly, I will agree with Your Honor that it's an existential impossibility for something, for a person or entity that does not exist to do something. But the question is not whether or not the physical act was carried out by a ghost or something that doesn't exist. The question is, what is the effect of that action? And it's undisputed that Restoration Doctor Inc., which filed the original complaint and the amended complaint in this case, it's undisputed that Restoration Doctor Inc. never existed. The appellee and plaintiff below is admitted to that.
When you refer to an amended complaint, I just want to make sure I understand correctly. What was the amendment other than the change in name, substitutive party under Rule 17?
I think there was some, there was at the very least, there was a change in terms of the amount owed. There was a payment made by the church.
And those things need to relate back. Does the name need to relate back?
Okay, so the name, there's a provision within either 15C or 17A, but the relevant rule that applies here says that you allow for liberal relation back if the wrong party was named. But that's generally considered when the wrong defendant is named. So the plaintiff doesn't have full control of the facts, that there's been no discovery in the case, and the plaintiff names an entity that they think have the liability for a contract or for a tort or whatever the case may be. That certainly would relate back because the party that filed the complaint is not in full possession of the facts, and the court gives them the deference that is owed in that circumstance. Here, the plaintiff is the master of its own complaint and had the ability, okay, so the first complaint was filed, wrong entity. The second complaint was filed, wrong entity. And it's not just those 2 circumstances that point to what happened here. It's the fact that the wrong entity throughout the life of this.
I just want to understand your position. If I file a lawsuit today and I misspell my name, I forget to put the H in my last name so that it's more phonetically pleasing. And then a few years later, I say, oops, sorry, I misspelled my name. Let me put the correct spelling of it there. You think that needs to be within the statute of limitations?
Yes, Your Honor, but there's more facts here. It's not quite as simple as that.
Well, I want to talk, well, but if your answer is yes, I want to talk about what sense that makes.
If it's a typographical error, you spelled your name wrong.
Mm-hmm.
Okay, but clearly you are the person that filed the complaint. Let me just clarify. You are the person that filed the complaint. That is a different circumstance than what we're facing here. It's not a simple misspelling where like an O was left off. It's Restoration Doctor Incorporated when there are multiple other entities that have claimed the rights in this lawsuit. There's Restoration Doctor LLC, already singular.
Although you're on full notice of which one you had a contract with, right? There's not a notice problem here.
Under the law that we are relying upon, Your Honor, Stein v. Smith and the Dual case, both Maryland cases, because there's no case on point in the District of Columbia.
Right, can I just pause right there? Do you
Yes.
think this is a procedural question that we apply our own law on, or do you think we're bound to look toward Maryland law?
Okay, so there's no question that 15C is governed by DC, this court's rulings and the rule itself, and that substantive Maryland decisions are persuasive as to substantive Maryland law.
Sure.
But this is not a pure procedural question that falls within the rule. So 15C sets out circumstances where the complaint will relate back. This situation that we're in right now has not been addressed. It's an issue of first determination. The court, and I can go back to some of the case law for guidance on this.
I mean, I think it's true, so far as I've been able to tell, that in a sense, this is an issue of first impression in this court. But we have certainly said, somewhat repeatedly, that we sort of disfavor these technical arguments and prefer to get to the merits of a claim. And this seems to me like an exceedingly technical argument about whether or not Restoration Doctor singular versus Restoration Doctor plural has, like, whether or not that error on the face of a complaint is enough to effectively dismiss it. I mean, that seems at least contrary to the spirit of our cases, even if we haven't addressed this precise circumstance. Do you want to respond to, am I wrong?
Certainly, Honor. You're absolutely right that 15C allows for liberal relation of pleading. I can't deny that. Or liberal relation back of pleading. There's no question about that. What is at question here is the effect of a complaint that was filed by a non-entity, not the circumstances that are set forth in 15C and 17A, but the question of whether a non-entity which files a complaint can have that complaint be the marker post for relation back.
So are you saying in Judge Deal's hypothetical where he files a complaint without the H, it's being filed on behalf of a non-entity, even if he is the person signing the complaint and sending it to the courthouse?
Those are, so I would not hold that against Judge Deal in those circumstances.
Appreciate it.
Yeah, but the circumstances are far different from that. That is a simple typo. Perhaps Judge Deal's attorney or the person proofing the brief just missed something. That can happen. What happened here was Restoration Doctor Inc., which never existed. Again, no dispute about that. Filed the complaint, filed the amended complaint, and then numerous other entities were raising their hand and saying, we own the rights to this. So the question of what entity is at issue here, it's not.
Did United House of Prayer file an answer to the complaint?
United House of Prayer did file an answer to both
In
the
their
original
answer?
complaint and the amended complaint.
Excuse me?
To both the original and the amended
The
complaint.
original complaint. And in the answer to the original complaint, did United House of Prayer say anything like, we have no contract with some sort of entity known as what is it, Restoration Doctor Inc.? We've never heard of Restoration Doctor Inc. We don't think it exists. We moved to dismiss, did they do that?
In the original answer, to my knowledge, Judge Glickman, no, I will check for you.
Actually, I'm wondering how they're really prejudiced by this error. I mean, let's suppose the lawyer goofs up and thinks the name of his client or her client is Restoration Doctor Inc. and when it's really a Restoration Doctor LLP or LLC, or, you know, I've seen LLCs and LLPs. It's easy to write P when you mean C. What prejudice, what conceivable prejudice can United House of Prayer really claim to have sustained as a result of this, to me, perfectly benign error.
So let me answer your question directly first, Judge Glickman. The prejudice issue as to how they were prejudiced. I mean, we're before you today. There's a lawsuit and there's a judgment against UHP today. But more importantly,
Well, I mean, right, well, if they had spelled the name correctly in the complaint to begin with, then we'd still be, I think, before you just have one less issue, but you'd still be before us here today.
well, that's not necessarily the case, Judge Glickman, because Judge Campbell, the Superior Court judge, used this issue of prejudice as well in his decision. It was a basis for his decision that there was no prejudice to UHP and therefore harmless error. We're going to allow it to relate back. But the issue
I'm not
is,
sure relation back, by the way, is the right way to think of it, but it's really just correction of a typographical, of an error, correction of a equivalent of a typographical error of a mistake.
given the trial court record, I can't fully agree with you, Judge Glickman, but I respect your point. The decision below is based in part on this prejudice issue that Your Honor has raised. The issue, however, is an issue of standing. And standing, the burden is on the plaintiff to demonstrate standing throughout the course of the litigation.
The plaintiff says that's really us. It's just that we gave the name wrong, but that we have standing. And that is really us. We meant it to be us. It's exactly like Mr. Deal leaving out the H in his complaint.
And if there were a circumstance, if this were a circumstance where Restoration Doctor Inc., the non-existent entity, which as it did in this litigation, followed the original complaint, if that happened, and then Restoration Doctors LLC, the party that claims the rights, came forward within the statute or even after the statute and said, whoops, we made a mistake here. It's really Restoration Doctors LLC, that's the party in interest. And had that been done promptly or even promptly after the running of limitations period, that would be a different scenario. But the scenario we are in is not that that was done promptly, but that Restoration Doctor Inc. files the complaint, the amended complaints, and now they've had a chance to look at what happened. They didn't change it then. And other entities, Flood Doctor, are claiming the debt. The only reason this ever got changed, the only reason that they moved to substitute Restoration Doctors LLC in is because UHP filed a motion to dismiss / motion for summary judgment where they raised these issues and said,
Yeah, but the rules contemplate that. I mean, what Rule 17 says is, well, don't dismiss the suit unless you allow an amendment to name the real party in interests, and then they're allowed to amend it. And we have said, by the way, that that is not a jurisdictional requirement, that the real party and interest requirements of Rule 17, although I will grant you case law has been all over the map on this question, but I'm looking Martin versus Santorini and Glasgow versus Khomeini that says, real party and interest hiccup is different from an actual jurisdictional bar. It is, there is standing, and it's just a question of whether or not you've identified the person who holds the right to bring the suit. And that is something that Rule 17 allows liberal amendment on. Otherwise, Rule 17 wouldn't exist. You would, because standing is judged from the inception of the suit, and you wouldn't allow that type of amendment.
Right.
So I'm not sure there's a question there, counsel. If there's anything there that you'd like to respond to, please feel free.
well, I'd have to look at the Martin and Glasgow cases to see what the circumstances are. I would just say, without knowing those cases, I don't want to represent what they say, but the typical case, my understanding, the typical case where there's a misnomer or a misnamed party, it's the defendant that's misnamed, as I mentioned in my opening.
I mean, I see the appeal of sort of being strict about this. If what you have is like a placeholder plaintiff, if you have somebody who's just serially filing lawsuits and then searching for the correct plaintiffs, if I file a clean water type action in Maryland and say, this water is polluted and it's harmed me and we've got damages, even though it's definitely not me who suffered that. And then I just start, and the pollution happened, 2 years and 11 months earlier, and I'm about to be barred by the statute of limitations, but I'm an entrepreneurial guy. I'm going to go file that suit, and then I'm going to go searching for plaintiffs to rename them. That makes a lot of sense because the defendant wouldn't have notice that we wouldn't want a later amendment to sort of somehow skirt the statute of limitations by a relation back principle. I still have not heard the case why it would make sense for such a technical error in a caption. I take it your answer is something like, well, there was a Restoration Doctor singular, but I still don't know why that's a notice. Like, how did that prejudice you in any way?
Let me answer that quickly, and I want to save 30 seconds for rebuttal. I didn't mention that at the outset. For the issue of standing, where the party that is before the court needs to show that it has standing to bring the case, and for the examples that I've already mentioned with regard to the other entities that were claiming the rights. There's a conflict here as to whether or not one party has the rights or the other, and that's the circumstances we face here. I have 30 seconds left.
We'll give you a little more time.
Okay, thank you.
I want to make an observation, though, that strikes me in listening to this back and forth. In a way, the fact that Restoration Doctors, Inc. is not an existent and was not an existent entity actually works against you rather than in your favor. Because if it actually were a different entity that existed, then you could fairly argue, look, that entity sued us. That entity has no standing. And, we want a dismissal. We want the relief we're entitled to against that particular entity. But here, nobody says this entity existed. It was just a misnomer. It was there's less of a reason to be strict about this.
I would argue, Your Honor, that the fact that, okay, so let's,
I mean, everybody understood, who you've been dealing with. By you, I mean your client
right.
knew who it had been dealing with, and nobody was fooled by thinking, oh, I didn't know this party was in this case. So it's very hard to see why the probably lawyers glitch in drafting the complaint initially should make any sort of difference here and can't be just corrected.
Well, two answers to that question, Your Honor. First of all, it's not just that the mistake was made and someone messed up. The entity continued to represent itself as Restoration Doctor Inc. in the amended complaint and in discovery, by the way. Their discovery responses, this is in our brief and it's in the record. In the discovery responses, they continue to represent themselves as Restoration Doctor Inc. So that's an important fact. I think
Restoration Doctor Inc.
Restoration Doctor Inc. That's right. So that's the first thing. The second thing, again, the issue of standing. It's their burden to show standing before the court and show that they're the real party in interest.
So
I understand.
how do you square that with 17A3, which talks about joinder of the real party in interest where they're not there originally? And it says that the case will proceed or the action proceeds as if it had been originally commenced against the real party in interest. That seems to both account for the standing concern that you've raised and also dispense with the need for any sort of relation back under Rule 15.
I would argue, Judge Ali Khan, that the issue the issue you presented does not address the issue of the effect of the filing of a complaint by a non-entity. Those neither 15C nor 17A discuss or contemplate that precise scenario. And that has been resolved. It's again, there's no DC Court of Appeals case on point. Either way, the authority that has been remotely on point is the Strother and International Tours case, which deals with capacity.
Those cases don't seem to get you that far, though, because they're about entities like corporate entities that had lapsed by the time they brought suits, and so you couldn't substitute someone totally different in the action. Here I'm sympathetic to Judge Glickman's thought that this is really just a Scribner's error, and they were substituted with the proper name. You are on notice of that, and under the operation of Rule 17, we just go merrily along to the merits.
And again, Judge Ali Khan, I would just respectfully rest on my argument that with regard to the effect of filing the complaint, we would ask this court to, as it has not addressed the issue yet, to adopt the approach of the Maryland Court of Appeals and also the Virginia Supreme Court, which have held that complaints filed by non-entities are nullities and have no legal effect, and specifically have no legal effect with regard to the relation back.
You may want to touch on, before you sit down, some other arguments. We spent a lot of time on this particular one, maybe more than you expected.
Thank you, Your Honor. So there's two main substantive issues. There's the contract issue and there's the the successor issue. The contract issue is fairly straightforward. Maryland law requires price and scope terms to be part of a contract in order to be enforceable as to those terms. They were simply not in this case in the original work authorization agreement. The Superior Court found that, quote, legally unimportant. Those were the exact words that it used. That was error, because Maryland law, which no one disputes, applies in this case, says that material terms have to be in a contract, and price and scope are in that group of material terms. I can expound on that if you have questions.
I guess I read those cases and I read them to say when there's some dispute about whether or not there was an enforceable contract at all, about whether there was a meeting of the minds, the fact that the parties had not agreed on a price term, well, that's going to be dispositive. Then if that's like, that is always going to be material, so you can't enforce a price term that wasn't agreed to. I don't read them to say that parties can't have an indefinite price term if it's clear that that's what they agreed to. And here, it seems clear that that's what they've agreed to. I mean, do you have a different reading of those cases?
Well, the Glassman case, certainly Judge Deal says differently. The Glassman case is a case where there's a contractor, working at a shopping center, and they have a contract with the shopping center. It's District of Maryland case, but it applies Maryland law. They have a contract with the shopping center with regard to doing various projects that are the shopping center, the landlord requests. And the landlord.
Can I just, I'm going to take a guess to see if I'm right about this. That involved a pre-performance breach or a breach before the services had been rendered. And then you couldn't try to claw back the money for all of the services that were never actually performed. Is that what Glassman looks like?
My understanding is no, but I'm happy to check.
Okay, no, I mean, if it looks like this, where really what you're trying, what doctors plural is trying to recover is sort of a quantum meruit, services already rendered under a contract. Well, then I will read Glassman with close care. I think I looked at all the ones that were cited, but I'll take another look at that one.
Right. Just the one point on that, Judge Deal, that is important to take away is that the court found in Glassman that an open-ended price term was unreasonable because the contractor, there was an open-ended price term in the contract, and the landlord could work with the tenants and deem whatever work needed to be done, and it would be built to the contract.
But yeah, no, I mean, I would think it would be subject to some sort of reasonableness analysis, but that occurred here, right? You know, if somebody says, look, we're going to perform the work, can't say exactly how much it's going to cost, but you know what needs to be done and we know what needs to be done. We're going to go in there and do it. Then if they came back with a bill that said that was totally out of proportion to the work that was performed, I would think you'd have a very viable defense to say, well, there's no way we're paying that. That's unreasonable. But here the work was deemed reasonable. So it strikes me as quite a bit different. I mean, again, I will go look at Glassman, but if Glassman is a case that relies on that principle, I find that unsurprising that there needs to be a reasonableness constraint on any open-ended price term, as that's just kind of fairly right into the contract. But if it says more, and if it says, well, actually, even if it's reasonable, although this would surprise me as a principle, it would surprise me to find this principle, even if the parties agreed to an open-ended price term and the work that was performed was reasonable, that's still not enforceable. That strikes me as rather surprising. I would think I could go to the vet and say, you know, my dog is sick, he's on his last legs, I will pay whatever it costs to keep him alive. And if the services they render are then within reasonable amount, I would think that contract would be totally enforceable, and it would be bizarre to me to learn otherwise. But maybe Maryland law is more bizarre than I realize, and I will look at it.
Well, I mean, when I read Glassman, if I just follow up on this, it was extra work. So to me, it seems like the hypothetical here would be they did the whatever restoration and the remediation, and then they went ahead and built an addition. So they can't recover for the addition, right? But here, this was all within the scope of the contract. And so it's not like that sort of extra work that Glassman contemplates.
That's not the only issue. I mean, you're right, Judge Alarcon, but that's not the only issue with this contractual relationship, I think is the best way to put it. There was an insurance estimate, which was proffered by UHP to the contractor, which at the time was Restoration Doctor LLC, we believe, not the current party, but that's not germane. There was an insurance estimate tendered for $282,000, plus an agreement that additional third-party work would be done and that there's sums would be added to that. The $282,000 insurance estimate was sent, and the president/CEO of the company received the estimate, and then 4 days later said in an email, we can go full speed ahead because you've put this deposit, there was a certain deposit that had been put down, we can go full speed ahead. We argue that that's an offer and acceptance. And it's not like the contractor said a month into the work, hey, by the way, here's an estimate for what you're going to spend. There was no estimate provided ever by the contractor until this bill was sent 7 months after the termination.
Can I ask you a question about this? And put aside the question whether there was offer and acceptance for a moment of the insurance company's numbers. I have the impression that the record supports the view that there actually was an agreement between the restoration doctors and UHP's representative as to how this would be charged and paid. I don't remember the name of the tool that restoration doctors used. It was something like AccuEstimate or something like that.
Xactimate, Your Honor.
Excuse me?
Xactimate. I believe I'm
Xactimate.
pronouncing it right.
I
Mr.
wonder,
Peacock
right.
can correct me when he's up.
I didn't even know how to pronounce it. And I thought there was essentially evidence that there was an agreement in which restoration doctors said, look, there's a huge amount of work here. And we're just going to do it in accordance with Xactimate's method of calculating the costs, and that's what we'll charge you. Well, you know, there might be some factual issues here, but that was what was acceptable to at least one could find that was what was acceptable to UHP. And in the event, when you totaled it all up, it came to a larger number than UHP may have foreseen. But there was an agreement under that view of the evidence as to what the price would be and how it would be determined. And I would think that would satisfy any requirement of Maryland law that a material term, that price and material term of the contract be agreed upon. What's your response to that view of the evidence?
So I agree that there's evidence in the record that the parties at least discussed Xactimate and whether it would be used in or around the time the work authorization agreement was signed. I don't think there's a dispute about that. The question is what that means. So Xactimate is not a monolithic software program where you just enter number 6 and you get number 15 in response. It's all in how you enter it into the program. There was testimony on this below in the trial court record. I can get the sites for you when I come back after Mr. Peacock, but that Xactimate depends on how you enter the data. You know, there's a lot of variables that control what the ultimate price will be, including your location and things like that. But there's evidence in the record that shows that RD Singular, the party that was operating the contract at the time, entered in things as bid items, which by nature increases the price of the item. So whether the parties agreed to Xactimate, there's certainly a fair argument that they agreed to that, but how that was used and how the numbers came out, there was no agreement, I would argue, as to that.
Gee, I wonder whether, I mean, I could well imagine a dispute in which UHP said, you know, we agreed to that you use Xactimate fairly, and you've used it properly in some respect or other, but I didn't think that was the way the issue had been framed before us.
Well, the issue whether the costs were fair were raised in,
And actually,
in the Supreme Court
well,
below.
the
Now,
cost of
Judge
fair
Campbell
was
found,
raised, and the judge, right, and the
Right.
judge found that they were fair, and I don't really see a serious dispute about that on appeal.
right, we're not disputing the sort of line by line, you know, was item X fair, was item Y fair? The issue is a contractual issue.
So that
As to
really,
what was binding on the
so that
parties.
really does suggest to me that the answer to this objection is there was an agreement on price, and it was the Xactimate price. And one could fuss about whether the Xactimate price has been properly calculated, but that issue hasn't been really raised. And so that's where we are.
But in a contract, Judge Glickman, there has to be a meeting of the minds as to what the material terms mean. Clearly, these parties had, regardless of whether restoration doctors use the software properly or not, there was a difference in opinion here as to what this meant. That's why Maryland law says that price and scope have to be defined as material terms. That's what the Glassman case says. Because if you have an open-ended price term that can lead to literally endless liability, you know, relatively unlimited liability, it's an
But
unreasonable.
parties can agree to that. If I have an agreement where I says, look, there's a lot of work to be done here, and I don't know what's going to happen, but whatever it is, I'll pay the Xactimate price. Implicitly properly calculated, but I'll pay the Xactimate price. I may end up with a bigger debt than I expected, but that doesn't mean I didn't have a contract.
But those aren't the
I took
facts
the
here.
risk.
Judge, respectfully, those are not the facts here. If the contract said what you've just said, that
Well, this was an oral addendum to the contract. I don't think they put in writing, unless I'm mistaken. I don't think they put in writing, we're going to do the Xactimate price. But that's what they talked about, and that's
Well-
what they said they were doing. Why can't that be treated as part of the contract?
Because the insurance adjusters, as I think one answer to your question, Judge Corcoran, is the insurance adjusters estimate, the 282,000 that UHP contends is binding on restoration doctors plural. That was also done by Zactimate. That is an understanding of what Zactimate, that is based on an understanding of what Zactimate would yield when those figures and numbers, I'm not as adept with contractor terms, but when those figures and numbers are entered into the database, the insurance company did this already. And they did it through Zactimate, and that estimate was submitted to Mr. Darakhshan. And Mr. Darakhshan not only didn't protest and say, wait a minute here, this is way too low. We have our own numbers and you'll get those in due time.
Can I just ask for a clarification? There was a prospective Xactimate from the insurance company, Travelers, right? There was
That's correct.
never an after the fact assessment of what work had been performed and how they would calculate that under Xactimate, right?
I think you're mostly right, Judge Deal. There was I'm not sure what the exact wording is, but in the spring of 2013, there was a document that's in the record, I believe, and I can point you to it after the break, that says that repeats that $282,000 number. So that this is after the work was done. But the estimate that I'm discussing that you've just referenced, that was before the fact, before the work
Sorry,
started.
I didn't mean to cut you off. I just wanted to make sure I understood correctly. Thank you.
If I'm well over time, I just like to reserve a little time for rebuttal.
We'll
If
give
your
you
honors have any other questions.
I guess I do have one question
Sure,
with
go
Judge
ahead.
Glickman's permission. Have you waived the argument about the $150,000 applying to principal versus interest?
No, we have not, Judge Ali.
And what's your 2-sentence summation on that?
The issue as to what was owed, the sums to be owed under the contract were raised both during the final briefing below the original trial. There was not the briefing, the presentation, the final closing argument that was given. There was a demonstrative and showing what the prices were, which was presented by UHP in the trial court below. Mr. Peacock for the plaintiff gave their own presentation as to that. Judge Campbell, when he was going through his verdict, which is in the record, went through the amounts that were paid and what was credited interest and principal. And my co-counsel, Ms. Bailey, corrected him on the amount that was discussed. So I don't think that issue's been raised, that has been waived at all, Your Honor. Thank you, Your Honor, for the extra time.
Yep, we'll give you a few minutes of rebuttal. Mr. Peacock?
Good morning, Your Honors. Stuart Peacock on behalf of Frank Darakhshan Restoration Doctors LLC. I introduced Mr. Darakhshan, who's in the courtroom. He's the same Mr. Darakhshan that showed up the night of the flood, and he's the same guy here. So I don't think there's any chance of confusion amongst who the proper plaintiff is.
He's not a corporation.
Well, it's an LLC.
Joke, I'm sorry.
He's the sole owner of the LLC. And he was the sole owner of Restoration Doctor LLC, the signature to the contract. And he's the sole owner of Restoration Doctors LLC, which is a successor in interest to Restoration Doctor LLC. I'd like to start by saying that when we tried this case, we established that all of the charges were correct, reasonable, associated with the remediation and with the restoration of the property following the flood. There was an ample opportunity for United House of Prayer to challenge all of the charges that we made. We went through the invoices in some detail, and there was an opportunity for United House of Prayer to make its arguments as to work not being properly completed. And those factual issues were resolved in favor of Restoration Doctors. I would like to say also that in connection with the interest issue, we went into trial with, pardon me, a demonstrative exhibit, and there's a record citation to that. Oh, I see. It's Appendix 429, and that sets forth the methodology for calculating the damages, including the interest.
Can I just ask a basic factual question, which is this payment, this $150,000 payment was made when? September 2016?
That's correct, Your Honor.
Is it clear from the record that there had been $150,000 worth of interest that would have accrued, I mean, penalties and interest at that point in time?
Yes, Your Honor.
Okay.
There was interest accruing at the rate of 18%. It far exceeded the amount given the passage of time. This contract was performed in 2012 and the beginning of 2013 at 18%. It didn't really take long for it to exceed that amount. Anyways, continuing with that, there was an opportunity for counsel to object to the presentation that we made as to how the interest was applied. The most that counsel did do was say, hey, we paid $530,000. We didn't pay $380,000. But they didn't say that money should be attributed to the principal. They had the opportunity to do that. The strongest argument that I think I've heard is that in our amended complaint, we mentioned the payment of the $150,000, and I'm rounding off the number, and that we were bound by what was stated in the complaint. We submit that it doesn't exactly say what it is that United House of Prayer says, but we were able to, we would be able to amend the pleadings at any time according to the proof that was presented. And the proof that was presented was consistent with the statements that we made in court, which is that we were applying the principal, we were applying the interest, we were applying the payment.
Yes, so as I understand the argument, it's, you know, in your amended complaint, you said there's a balance of $511,000. That is a judicial admission that precludes you from later saying, you know, apply that. Let me see if I have some. I'm just reading from page 20 of the reply to see if I have this right. That was a judicial admission of fact that that was the outstanding balance, $511,000. And well, I guess I am missing the step as to why they think that means the $150,000 needs to apply to that. But is that what's missing in their argument?
Well,
Or I guess let me I might ask them for clarification of it. But I understand there is to be a judicial admission of fact type argument. Is that how you understand it?
I believe that's the argument that's being made. I would respond to that by saying that there's been no detrimental reliance on that allegation that would be an estoppel against going ahead and making the argument that we made at trial. Furthermore, I
guess they're not, but judicial admission and detrimental reliance don't need to go hand in hand. I mean, if somebody says, look, we made a $150,000 payment, that reduced the amount that was due to $511,000. If that's the plaintiff talking, I think what they're saying is, and so you've admitted that that was the only, you admit that it goes against the principle. And you're bound by that going forward. I think that's their argument. And your argument is, no, we weren't being so clear about that, and we're free to take a different position as the suit progresses. That is too fine of a reading of the complaint to really give any preclusive effect on a judicial admission theory. Is that it?
Yes, Your Honor. I believe that that's their argument, but I'd also say that in the amended complaint, we said no less than $511,000 and subject to proof at trial. And I think the clincher on the issue is that it was waived. This is not something that was brought up at the time of trial. There was an opportunity to file a motion for reconsideration. There was an opportunity to stand up and object at the time that the verdict was read, and there was no objection on those grounds.
I know we're hopping around a bit, but you briefed relation back under Rule 15, and I guess I'm wondering, do you think Rule 15 has a role to play here, or is this all resolved by Rule 17 substitution provisions?
Well, Your Honor, I believe that it's all resolved by Rule 17A, but if you look at Rule 15C, I think that that fits too. And the reason that it fits is because the claim arises from the same set of facts, involves the same persons. It's not a new claim in any sense of the word. The only difference was that it was asserted in the name of Restoration Doctor Inc.
I guess, I mean, maybe I'm missing something because you guys spill a lot of ink on Rule 15, but I don't see any sort of amended complaint that needs to relate back, which is why I'm having a hard time kind of fitting this case into the Rule 15 analysis.
We agree, Your Honor, that it doesn't make sense to have to apply the Rule 15C, but this was presented as kind of a gotcha moment. We found a way that we can defeat this debt, and we're going to press every button we can to see if we can do that.
I will say, I mean, so Rule 17 A3 speaks in pretty sweeping terms. It says, so long before you dismiss, allow a substitute plaintiff, and that will always act as if the statute ran from when the initial suit was filed. But there must be some relation back principle, because otherwise, I mean, I think, what do you think about the placeholder plaintiff hypothetical that I asked to opposing counsel, where if I'm just an entrepreneurial squatter on claims, and what I do is I look for bad actors and I go to their jurisdictions and I file lawsuits under my own name, and then I go shop just under the wire of statute of limitations, and then I go shopping for substitute plaintiffs who might have actually been damaged. I assume you'd agree with me that can't be okay. That it's not always a Rule 17 substitution is permitted in circumstances like that.
Well, I agree, Your Honor. There are some cases out there that talk about the placeholder situation. This isn't a placeholder situation.
Although I will say, I mean, you can at least imagine reasons why your client might want to file under a different company name. If your client owns Restoration Doctors LLC and once owned Doctor LLC and has 7 different corporations under similar names, it might turn out that 3 of them have massive judgments. Maybe the contracting party had a massive judgment levied against them that's going to preclude them from ever getting a dime of that money because they want that company to go bankrupt. And so they bring a suit in another company's name to collect. And if there were that type of strategic filing, do you think that might preclude an amendment later?
I think it might, Your Honor. But in this instance, we fessed up at the beginning, or when I got involved in the case and realized that there was an error. We said this is an attorney's mistake. We used Restoration Doctor Inc. when we should have used Restoration Doctor and then Doctors LLC.
It's sort of like an alias or also known as situation.
I'm sorry, Your Honor.
Well, it's sort of like a stage name or an alias or a doing business as name. If a party that has the real name of X but does business under the name Y were to file a complaint, Y versus so and so, you would think that the party could also eventually say also known as or X, or fix that without having any sort of claim being made that it's too late to do it.
Your Honor, what really happened is the prior attorney did a lot of work for Mr. Durakshin in a company called Flood Doctor Inc. and got the name, was used to using it. If you see, there is in the record a demand letter that was written by one of the attorneys, and it was asking for repayment on behalf of Flood Doctor Inc. It's all consistent with the explanation, and the explanation makes total sense.
I just want to make sure what's good for the goose is good for the gander. If I had hired your client to fix my basement and I had a dispute with him and I was the plaintiff and wanted to sue him, and I had it, Lauren Ali Khan versus Restoration Doctor Inc., you would accept that as a suit that you would litigate and not one that you were, I had named the wrong entity, I should go after whatever Restoration Doctor Inc. may or may not exist in the world.
Yes, Your Honor. I think it's just a technicality that could be raised to try and defeat a debt. But the proof that we presented at trial in the remand trial was that the Restoration Doctors LLC was a successor and that they had the same employees, same trade dress, same taxpayer ID. And it's not an attempt to obfuscate who the real party in interest is.
And I guess that gets me to maybe a silly question, but one that sort of flummoxes me. There's a lot of ink spilled on RD singular and RD plural being the successor, but that's Restoration Doctor LLC and Restoration Doctors LLC. And so it seems like, at least in the appellate briefing, the Inc. versus LLC is kind of fallen in some ways out of the equation. I know your friend on the other side says, well, because it was Inc., it means they never existed. But, you know, do we need to sort of decide, like, can we resolve this just on kind of successor between RD singular and RD plural, or do we need to do some gymnastics to get around RD Inc.?
I don't think so, Your Honor, because the relation back doctrine would prevent the statute of limitations from barring the claim.
Okay.
Anything further?
If
Your
you
Honor?
have nothing further.
Thank you very much for the opportunity to argue in front of you. It's been an honor.
And we'll hear, thank you. And we'll hear now from Mr. Schmidt in rebuttal.
Yes, quickly, sorry. Quickly, Your Honor, since the successor issue came up with Mr. Peacock, I want to touch on that. First of all, Judge Ali Khan, your question as to whether we can get around the RD Inc. question, it's a separate issue. Because you still have to, even if you find that 15C works here and that you can relate back and that it's not a problem, they still have to show that Restoration Doctors LLC, the entity before you, is the successor to the party that signed the contract. So it is an additional hoop for them to jump through. Let me give you, Mr. Peacock mentioned the evidence that was the testimony of Mr. Droxham regarding same uniforms, same bank accounts. I can't remember what else he said, but I mean, roughly along those lines. There was contravening evidence here in the record that RD plural was not the successor to RD singular as a legal matter. And we can see that just from RD plural's own actions or inactions at the time. Let me just run you through them really quick. The final invoice was sent by Flood Doctor. Both the cover email and the invoice itself said it was from Flood Doctor. 9 months after RD plural was formed in May of 2013, Mr. Peacock has already alluded to the fact that Paragon Law Firm sent a letter to the church on behalf of Flood Doctor Inc. making a demand. So again, RD plural has not raised its hand at this point. RD plural filed the initial, RD Inc. filed the initial complaint on April 7th, 2015. We've already been through that. There was no RD plural named. The plaintiff referred to itself as Restoration Doctor Inc. throughout the discovery period. The amended complaint was filed by RD Inc. on November 1st, 2016. Now we're several years into the dispute. And Mr. Droxham confirmed that as of the date of each of these stages, he had not informed UHP about any continuation, successorship, or assignment. And even after remand, RD's brief suggested that the trial court could choose from one of three different entities to enter the judgment on behalf of: Restoration Doctor singular, plural, and Restoration Doc, a new entity, LLC. So I think it's fairly clear from the record here that the evidence of successorship is at least muddled, to say the least. Thank you, Your Honors, for your time.
Counsel, thank you both. The case is now submitted. The court is going to take a brief, roughly 5-minute recess now, and we'll be back in 5 minutes.
All right. All right. This court is back in session. Please be seated and come forward.
Thank you. We'll call the third case on our calendar. NIZAR ZAKKA versus Palladium International.
I'd like to reserve 3 minutes for rebuttal, please.
Excuse me?
I'd like to reserve 3 minutes for rebuttal, please. May it please the court. The Superior Court's decision in this case was.
Excuse me, may I interrupt you? Would you identify yourself for the record?
Oh,
please?
sure. Adam Farah for the plaintiff appellant NIZAR ZAKKA. Sorry about that, Judge Glickman.
And would you like some time for rebuttal?
3 minutes. Thank you. The Superior Court's decision in this case was extraordinary. It held that private multinational companies are entitled to the sovereign's jurisdictional immunity from suit for everything that they do with respect to a government contract, unless the plaintiff can show on a Rule 12b1 motion as a matter of establishing subject matter jurisdiction, and that the company either violated a specific term of its contract with the government or otherwise violated federal law. The court then applied that supercharged immunity from suit for private companies in a case in which the State Department advised Palladium that proceeding with Mr. Zakka's travel to Iran was not a requirement of the federal government and was undertaken at its, quote, own risk. And it made that finding on the basis of a record that it curated for itself, in which it struck the only declarations from the only two witnesses in the case, and then barred the plaintiff from seeking discovery from the relevant actors, including the State Department, on whether they in fact authorized and directed the conduct that is at issue in this case. That was error all the way down, and it should be reversed for the three reasons we've outlined in our brief. With respect to the standard of review, I just want to make three brief points. One,
Before we get to the standard of review, I just want to hear your articulation of what you think the correct Yearsley standard is. So, I mean, I hear what you're saying, that you think the trial court applied a way too circumscribed, put your burden as way too high. You had to show something that was directly contrary to a direction. But like, what about, if I remember the facts of Yearsley correctly, it was something to do with, scooping down the shores of some riverbank, and that led to collapse. I take it you would agree that immunity might apply there if the exact, well, I mean, it definitely does under the facts of that case. I take it you don't need to show that the government directed you as to how to make each scoop of the soil. So long as you're fairly acting within the scope of the thing that the government authorized and directed, I think you would add, well, then you don't need to get that granular about it. Did they direct A, B, C, D, or E, every little aspect of it? I mean, how would you define it?
so I think Yearsley is a good place to start, followed by Campbell-Ewald. I think what the court said in Yearsley was that the act of redirecting the Missouri River, building the dikes in a particular place according to government specifications, and then using paddles that caused the erosion that destroyed the Yearsley's land was, quote, authorized and directed by the U.S. Corps of Engineer and the Secretary of War.
So you would need to show, if you wanted to get around immunity, you would need to show some deviation from the direction. Is that right?
I think, no, if you want to get around the immunity, if the conduct is not authorized and directed by the government, then there is no immunity. There are other ways in which the immunity can fall. So for example, that's what Campbell-Ewald is about. Whether Campbell-Ewald's use of a text messaging recruitment campaign specifically to individuals who had not opted in to receive those text messages, that was the operative part, whether they had opted in or not whether they, did the text messaging recruitment campaign at all, whether that specific part was directed, that's the term that Justice Ginsburg uses in Campbell-Ewald, by the federal government, by the Navy in that particular case. And the answer was no. And Justice Ginsburg then went a step further and said, and by the way, this notion that you enjoy the same type of immunity as the federal government has no support in our case law. That's what she said, that Campbell-Ewald couldn't cite any case law on that question, and that it was completely foreign and sovereign to any Supreme Court case, including Yearsley, which she discusses in depth. And she reaffirms that the standard is authorized and directed. Actually, in that case, she doesn't even use the term authorized. She just uses the term directed, which I think indicates the level of control that the federal government needs to have over a private company when they're asserting this Yearsley defense.
Counsel, what if we had the State Department email that says, you are authorized to go and we're so happy you're sending Mr. Zakka, period. Are we in the same situation or does it look different?
I think I still don't think they get the Yearsley defense because it's not a direction. And I think that, let me just back up and say, there are going to be hard cases. Okay. There are going to be outlier cases. We can talk about hypotheticals literally all day. This isn't one of those cases because we have that language. But to take your hypothetical, Your Honor, the answer I still think is no, that there needs to be a direction, authorization and direction from the State Department to send Mr. Zakka to Iran in the specific manner that we have alleged is reckless in the complaint, which is.
And could you just indulge me in one more hypothetical? So let's say the underlying contract with the government says you will send someone to Iran once every quarter. And so this quarter comes up and they say, we're sending Mr. Zakka, and the State Department says, travel authorized, we're happy we're sending him.
If the basis for is it the same claim, like the same type of claim we're starting here, which is recklessness in the manner and means that they sent him, I still think the answer is no immunity in that circumstance, because if all the State Department said was, send him to Iran, but they didn't take a position on what the safety and security protocols were for that travel. And they didn't tell him that traveling there as an affiliate of Palladium would paint a target on his back. Still, the answer is no. I don't think you have to get into that issue. I think it's a harder case, but I still think the answer is no.
I think the rule as you're articulating it raises one concern for me, which is that negligence by omission will always be available. You can always have a negligence by omission claim. So if you take the Yearsley example, what you could have said to get around derivative sovereign immunity there is, well, yeah, they trudged up this riverbank in the manners specified by their government contract, but they should have done a more thorough background of their operator. And they didn't do that, so that's the negligence. I mean, you could always articulate something like that, that in your view would get you around this immunity. Now, you might say, maybe your answer is, well, who cares? You know, good luck proving that claim. And, you know, if that's the claim, then, you know, then, oh, well. But I don't know, what is your answer? Is it, you know, can you always get around this just through artful pleading then?
No, you know, DC standard of care tort law is not subject to my imagination. I just can't come up with anything that I want and say, this was done negligently because, you know, you should have flown him on the Concorde and brought it back out of business.
I mean, I didn't make up something fanciful, you know, putting your operator through sufficient background checks and training seems like a perfectly plausible negligence claim to me. And I think, you know, this puts aside your security measures aspect of your claim, but on the failure to warn aspect of it, it would seem, I mean, I haven't tried, but I imagine if you give me any case where immunity has been granted, I could at least articulate a viable theory as to a negligence by omission. You know, you can always kind of tweak the claim a little bit by putting it in omission terms that would get you around immunity. That doesn't concern you?
It doesn't, except that in those cases where, for example, there is an extreme amount of discretion required by the contractor, like take a case like Taylor Energy from the Fifth Circuit. In that particular case, which the defendants are, you know, that's the case that they wrap themselves in. There was a federal statute that said that every single thing that federal, local, or private actors did with respect to containing an oil cleanup had to be directed. That's the term in the federal statute, directed by a specific person in the Coast Guard, a captain who is designated the on-site coordinator. In a case like that, where, you know, there's an emergency, there's a federal statute that dictates that literally every single decision has to roll up to a specific human being who's an officer of the federal government, you know, that might cabin, I think, to some of the circumstances that you're talking about. But in general, no, I'm not as concerned. And I don't think the United States government, by the way, is concerned about these types of cases either, at least not that particular concern. You know, if you read the United States' brief in CACI versus El Shamari, the Solicitor General's brief, okay,
which is not in the briefs here, right? Nobody's raised that yet.
I actually, we did cite
it.
it.
You did? Okay, I missed it. We
cited it in the reply. It's also actually entirely replicated in the JA. In that particular case, you know, the United States takes the position that, you know, one, the concern about discovery that is always raised by the private contractors, it's not really enough because the issue of immunity is always coterminous with the question of liability. That's one thing the United States says. The second thing it says is, you know, this is a narrow defense. The point is you are not the sovereign. You have a defense to liability if you did exactly as we told you to. And if you step outside of that, or if you did something else that we didn't direct you to do, you know, usual default system of justice in the United States applies, which is that private companies are subject to tort. With respect to the standard of review, I mean, we've covered some of this already, but the other point I want to make before I move on to the substantive legal standard, which we're kind of getting into.
I have one question for you.
Sure.
So, I mean, sovereign immunity, we understand, is jurisdictional. So if we do think that this is derivative sovereign immunity, is the fact that it's qualified not absolute relevant to transform it from jurisdictional to merits?
So if I understand your question, Your Honor, you know, if you think it's a qualified immunity, you know, think it's a narrower defense, does that lean in favor of being immunity or not?
Or jurisdictional or not?
Or jurisdictional or not? I mean, I think that the broader the defense gets, the less likely you should treat it as immunity, but I don't necessarily think the reverse applies. You know, I mean, I think if you read the United States' brief, they're pretty categorical. Their amicus brief in Campbell-Ewald versus Gomez, or amicus brief in CACI versus El Shamari, the statement of interest in Clover v. Camp Pendleton, it's not the same. It's just not the same. You don't get the sovereign's unique jurisdictional immunity from suit. And, you know, Palladium doesn't respond to that at all in their brief. So the second point I want to make about the standard of review, and then we can talk about the substantive legal standard. You know, Nobody mentions the scholar's brief in the defendant's brief. That's an extremely compelling brief for two reasons. Number one, it's not just some random collection of 5 civil procedure and federal jurisdiction professors. 3 of those scholars are the foremost experts on private contractor immunity in the United States. They have published every major article in every major law review on this issue over the last 4 or 5 years. So I would really commend the brief to you. The second point they make in the scholar's brief is a practical point, which is that if you treat it as a 12b1 issue, as a matter of subject matter jurisdiction, then it is the plaintiff's pleading burden to put it in the complaint that they violated a specific term of their contract or otherwise violated federal law. The plaintiff doesn't know what the contract says between the company and the federal government. We even tried to FOIA that before the complaint was filed, and we still haven't gotten a response to the FOIA request. And in a case like this, it matters what the communications are between the State
I mean,
Department.
how hard is it to say they didn't authorize and direct that activity, and then you've gotten past the pleading stage? I mean, you've at least gotten to some limited discovery at the pleading stage. I mean, I guess I would like to ask just about the real practical importance of this, because sometimes jurisdictional questions are very fact laden.
Sure,
You know,
yeah,
in the District of Columbia, we have, you know, Western Avenue and Eastern Avenue. We share a border with Maryland. In criminal cases, whether or not we have jurisdiction depends on whether or not you are on one side of the street or the other. And sometimes you have jurisdictional issues that get full vetting before a jury, before a trial court is willing to rule on it. It doesn't necessarily need to be kicked out at the 12b1 stage just because something's jurisdictional. Now, that's not, I know this is a civil rule and I'm talking in a criminal context, but still true. I think you might need full discovery on a jurisdictional issue, you know, rather than what occurred here. So I'd like to just get your take. And I didn't really get a sense from the scholar's brief about what the practical stakes are as to whether or not we couch this as an affirmative defense versus a jurisdictional one. I mean, I've heard you give me one answer, which is sort of it's judged by the pleading, but that doesn't move me because you just say they were not authorized and directed by the United States to do this negligent activity. All right, that's satisfied. What else?
So I just want to make sure the premise of your question assumes that they are wrong about the substantive legal standard. So the premise.
Sure.
Okay,
I mean, I didn't mean either way, but I mean, yes,
Sure.
If that's, yeah, sure. Use that as a jumping off point.
Okay. All right. So if that's true, if the question is whether the particular conduct was authorized and directed by the federal government, I understand you're not moved by it. I still think that's a problem because you don't know what the federal government said. I can plead it. I don't know what my good faith basis is for pleading it, but I can plead it. I mean, and in this particular case, by the way, you know, that was the first word out of Mr. Boyd's mouth at the first hearing. He said they didn't even plead the question of what the State Department said or didn't say on this issue. It's like, yeah, because I don't really know. You know, it's like we haven't gotten into discovery yet. I don't know what the State Department says. I just certainly don't know what the State Department thought afterwards. But to take, you know, your question, what happens at the 12b1 issue? I mean, I think this falls back into the concern that is addressed by the United States in the CACI brief, which is that, you know, okay, you want to allow jurisdictional discovery on this issue of subject matter jurisdiction. It's just going to turn into full-blown merits discovery anyway.
Well,
So
I think the distinction between treating it as a 12b1 issue and treating it as an affirmative defense. The practical difference is that if it's a 12b1 issue, the trial judge is making the factual determinations, is weighing the evidence, and is coming to a conclusion. The trial judge is the finder of fact here, the decider. If it's an affirmative defense, then the trial judge has a more limited role to play. The trial judge's role is simply to determine whether there's a genuine dispute about material fact, such that a reasonable jury might find the issue in favor of the opponent of the motion.
Yeah.
So that's a pretty significant difference, it seems to me.
yeah, that's true.
And reason enough for us to think hard about whether this is a 12b1 issue or not.
Yeah, I mean,
In general, what is your understanding as to how qualified immunity claims are treated in this regard? Are they treated as appropriately decided by the trial judge on a 12b1 motion? An absolute immunity claim would be, for example, sovereign immunity would be by the United States, would be treated as or could be, there are options here, but could be treated as a 12b1 motion for the judge to decide.
So I think the comparison of qualified immunity to derivative sovereign immunity, I mean, there are whole like law review articles written about the issue. I think to answer your question, my understanding is that qualified immunity, take it in like a section 1983 case, it can be asserted at the 12b6 stage. It can be asserted again at Rule 56, and it's a triable issue. There's a question of whether, except for the clearly established law prong of qualified immunity, which the judge, I think, typically resolves. There's also, I'm blanking a little bit on this. We haven't briefed the issue, and I should have looked closer into it. But I think under Rule maybe like 14 or something like that, there's like some circuits have started to apply a specific federal rule of civil procedure in qualified immunity cases to put a higher burden on the plaintiff to plead more specific facts to show that they violated a federal right, and that the law is clearly established. But I mean, I think, to get to this question about the comparison between qualified immunity and derivative sovereign immunity, I mean, in their version of it, derivative sovereign immunity for private companies is broader and more powerful and is decided earlier than qualified immunity for federal officers or state officers who are exercising and acting under color of law and exercising their rights under color of law. That doesn't make any sense in our system of justice. And I actually think in Campbell-Ewald, that issue came up and it was briefed a little bit. I don't think the court opined on that particular issue.
So I take it the United States' position is that we're in affirmative defense territory rather than jurisdictional.
Yeah,
territory.
absolutely. Yeah.
But qualified immunity also is immediate, or the denial of qualified immunity is immediately appealable.
Yes.
And I know the United States has taken a position that derivative sovereign immunity is not, and that sort of bakes into the jurisdictional analysis. But I guess, where do you put this on the spectrum of kind of absolute, qualified, et cetera, immunities?
So I think it is closer to, I think it's closer to qualified immunity, but weaker, if that answers your question. The point about interlocutory immunity or interlocutory appeal from the denial of immunity, that's an important point because it's most cases now, even the DC Circuit's most recent case in Brody, Judge Pillard writes, like, yes, we're going to exercise our jurisdiction to review this issue under the collateral order doctrine. But actually, from here on out, it's probably never going to be an appealable issue, the denial of this immunity issue ever again. And she says, like, our decision today is going to nudge colorable claims that would give rise to collateral order, interlocutory appeal under the collateral order doctrine to non-colorable claims, which I think sort of ends the discussion on that, because the Ninth Circuit came to the same decision in a derivative sovereign immunity case earlier this year. We didn't cite it, but the case is called Childs.
So in your view, if we were to remand this and then immunity was to be denied, you would not think that was immediately appealable?
No, absolutely not. I don't think so. The court hasn't ruled on it. I think if the court agrees with us on the Rule 12b1 issue, then I think the court will strongly clue everybody into whether the appeal of those issues you get an interlocutory appeal from the denial of that motion. But yeah, I don't think you would.
And this might be a silly question. I don't mean it as a softball. I'm actually genuinely curious. Here we have this sort of curious motion to dismiss, or sort of order dismissing for lack of jurisdiction, but we also have an alternative summary judgment ruling. I assume you think that summary judgment ruling wouldn't be an alternative grounds on which we could affirm. And I'm wondering if you could articulate why.
Well, so I think if we win on the 12b1 issue, if we win on the standard of review issue, I think the decision has to be reversed for a couple of reasons. One is, under Rule 56, the Superior Court Civil Rule of Procedure 56D and E, we needed an opportunity to meaningfully contest the facts that were purportedly non-disputed. We didn't get that, in any way, shape, or form. No depositions were permitted. We weren't allowed to serve TUI requests on the State Department. We weren't really allowed to do anything to rebut all of these purportedly undisputed facts. So as just a matter of process, this wasn't a Rule 56 motion that I've ever seen. Even on the smaller level, there's no undisputed statement of material facts submitted in this case, et cetera, et cetera. In terms of specific, genuine disputes of material fact that were apparent even from this very skimpy record, the fact that Ms. Hajilu's email says the travel is not a requirement under the terms of the program and is otherwise being undertaken at Palladium and the traveler's own risk, doesn't seem like a directive to me in the light most favorable to the non-movement. Also, it doesn't even really seem like authorization to me in the light most favorable to the non-movement.
So that's like an interesting question. If it's an affirmative defense, the light most favorable would switch to Palladium? Or would it still be interpreted in your view?
If they're the movement on the question of immunity and it's their affirmative defense, I still think under the Rule 56, regardless of what the substantive defense that's being asserted is, it's still the light most favorable to the non-movement.
I don't want to jump ahead if my colleagues have more questions on sort of the threshold issue. I do hope we can talk about
The substance, yeah.
the substance. And I know we prepped in and out of it. But so there's sort of two questions, or there's sort of two different varieties of claim. There's the failure to warn and there's the failure to provide security measures. And sort of a slightly prior question is how we frame the question, whether or not it's jurisdictional or an affirmative defense. I don't really think affects that. How do we frame what it is to have derivative sovereign immunity? So can you give me your framing of what the proper test is, and then walk me through. And I know this is a big task and it might take a while and you're sure to be interrupted before you do it, but at least start to walk me through each of the two claims you've got as to why you think it satisfies.
Sure.
Or that they have not satisfied the test for derivative immunity.
Sure. So sticking with the authorized and directed language, I think the way Judge Pan should have framed the inquiry is Mr. Zakka's claim that Palladium failed to warn him that traveling to Iran as an affiliate of Palladium would subject him to a materially heightened risk of targeting, abduction, imprisonment. Was that authorized and directed by the State Department? And then with respect to the safety and security protocol, actually, I think there's probably two ways you could frame it, but the easier one is, was the sending Mr. Zakka to Iran without taking any safety and security protocols, including the ones that were listed in the bid when they tried to get the money for the Wave 2 program, was that authorized and directed by the State Department? I think that's how I would frame the inquiry. And the answer to both of those things, at least on the current record, is no. And I'm not saying, and I don't think the court should write the opinion to say, Palladium never gets to make any arguments ever again. That, when we get to discovery, we get to discovery. They're entitled to make their case. And when we get to summary judgment, who knows, but
I'm surprised you're kind of reading it that strictly. I thought you would have said, unless there was an actual direction that someone put Mr. Zakka on a plane, then immunity is just out the window.
I mean, the thing about this whole, is the question whether it was the travel or whether it was the means and methods and manner of that travel. We went back and forth about that in the Superior Court. I think we went under either framing, quite frankly, but I just think that it's so unprincipled to frame it the way that Judge Pan did. I mean, every single case that is cited in the briefs frames it at the level of granularity that I'm talking about. And the best case on this is the case the defendants cite, the KBR case from the Fourth Circuit, where Judge Floyd meticulously rejects KBR's argument that the only question in the suit was whether they provided waste disposal sanitation services to the DOD. And Judge Floyd's opinion for the Fourth Circuit is absolutely not. The question is whether you used open air burn pits on unsorted medical waste on the battlefield and subjected all of these service members to serious health risks as a result, and whether that violated a specific order or guidance from the DOD, or whether they didn't express an opinion on it, and so you were just exercising your discretion in using that particular method of waste disposal. So I think that's probably the most powerful case rejecting this sort of framing question. But to go back to my original point, I don't think I need to win both. I think I probably went under either. So I think to get back to the meat of it, where I think Judge Steele seems a little more interested. I think the question in terms of how. There's the question of the granularity, sort of how do you frame the inquiry, which I think we've talked about. Then there's the question of the level of control. And, I'm not going to sit here and say every single case says it exactly the way that I say it, but most of them do.
Well, I think to piggyback on Judge Ali Khan's question, which I took to be a friendly one, was no matter how you want to define the level of granularity, had they been directed to put Mr. Zakka on the ground in Iran, they didn't even do that. So why are we even talking about granularity? This whole thing. I mean, Palladium looks, and I forget, JM3, I'm skipping a letter, I think, look a lot more like a grantee than a government contractor. There's no specifications about what they ought to be doing over there, right?
Absolutely.
I mean, there's no specification that they even put boots on the ground in Iran. Am I correct?
Correct. And in fact, there was no provision in the cooperative agreement that even discussed that. I mean, the provision that they're citing about travel is talking about travel generally. And there was a lot of travel for the Wave 2 program that wasn't to Iran. It was to Beirut, to Qatar, to a bunch of other countries. And so there's nothing in the cooperative agreement that even specified the kind of higher level of granularity. The reason why I think the granularity piece is important is two reasons. One is I think it's a clearer, more straightforward thing that Judge Pan got wrong, frankly. And then the second thing is that I think you do have to specify at least a little bit in the opinion what the test should be, because otherwise, at least, for purposes of this litigation and next, future litigations, like the parties need to know sort of how to frame that inquiry. And there's a case we cite in the reply brief, a case from the DC Superior Court involving like water treatment plants, and it's a question of municipal derivative liability, but the same fight is playing out in that case too, in the opinion, how granular you frame the inquiry. And the court in that particular case, takes a pretty strong view that it has to be pretty narrowed the way that we are framing it. So I think some clarity from the court would certainly be helpful, both for this case and future cases. I think there's only one other thing I want to touch on, and then I'll be happy to sit down and let Mr. Boyd talk, which is that you can't, even under Rule 12b1, let's say we lose on all these questions, 12b1, the substantive legal standard, et cetera, I think we still win because the discretionary function exception to the Federal Tort Claims Act that they have cited as the sort of basis for their derivative sovereign immunity claim, it really doesn't apply. And I was doing a little survey of the cases last night. I know this court, I think Judge Deal, you authored an opinion earlier this year on this question in a slightly different context. But the point is, who is exercising the balancing of economic, political, and social policy, and how does that balancing relate to the claims in the litigation? It's not even clear anybody is exercising any balancing of any policy decisions with respect to Mr. ZAKKA's claim. Certainly the State Department is it. They said, do the travel. It's not required under the terms of the program. Is there any political or social or economic consideration there? No. Palladium wants to go a step up in the chain and ask whether the State Department's decision to do this program at all was social, economic, and political policy. And the answer to that is it has nothing to do with Mr. ZAKKA's claim. His claim isn't that the program exists. His claim is simply—
What's the case where you think I discussed this?
Nash Flegler?
Oh, yeah, of course. Okay. Well, I find myself very persuasive, so I'm going to go back and reread that.
If there are no other questions, thank you.
Okay.
Good morning, Your Honors. Benjamin Boyd on behalf of the appellees, Palladium International LLC and Edward Abel. First, I do want to say that my clients expressed their sympathy and empathy to Mr. ZAKKA for the ordeal that is at the basis of this lawsuit. However, as Judge Pan held in the Superior Court, our client believes that Yearsley immunity applies here to shield Palladium and Mr. Abel from this lawsuit. The application of Yearsley does not involve the complexity in regard to requirements and no discretion that Mr. ZAKKA is setting forth. Instead, as we know from the Yearsley case and the Campbell-Ewald case decided by the Supreme Court, that the test, as you asked about, Judge Deal, is very straightforward. Was their authorization and direction validly conferred to the governmental entity? Was the authority validly conferred to the governmental entity, and did they authorize and direct the contractor to take action? That's number one. Number two is, did the contractor deviate or exceed that authority? That's exactly what they talked about in Yearsley, and that's exactly what they talked about in Campbell-Ewald. And if the court finds, as Judge Pan did, that the action at issue was authorized, then the contractor is immune from suit.
About half the time, counsel, you dropped out the word direction. I think I counted 4. 2 times you said authorize and direct, and twice you just said authorize. As I read Judge Pan's ruling, she thinks direction is not a part of this and mere authorization would be enough. So could you just tell me what, I take it, you don't want to go out all in on authorization is enough. You'll give me that direction needs to be part of it in some respect.
Yes, we have to figure out what authorization and direction means. I would agree.
And so why don't you, on the facts of this, tell me what was directed about the challenge, about what they allege to be the negligent conduct? Because, it seems like you're off to a bad start to me when there's no direction to send anybody to Iran. So you tell me what you think was directed, what relevant things were directed.
Yes, Your Honor. So first, I would say that there's no case law that says directed means required by the government. So there's no case that says that. In regard to our case, the directions are in the technical application, the agreements and the work plan. What was directed there was in each of those documents, if you've looked at them, they contemplate in great detail how this activity to promote women's issues in Iran is going to be conducted. So there's a monitoring and evaluation plan, and they're directed to do certain things to monitor and evaluate their progress. There's a work plan that directs them how to perform the work. There's specific requirements directing them how to conduct their travel to Iran, Beirut, Qatar, wherever they may be going. And it is specifically contemplated in the contract that there needs to be boots on the ground, so to speak, in Iran in order to achieve the goals of the contract. So
Now, your friend on the other side disagrees with that. So where in the record can we look to resolve that dispute?
I apologize. I don't have the site.
Is it in the technical application? No, that's not going to be it. Is it the waive agreement at 315 in the JA?
Yeah, there is a reference in the waive agreement to the travel to Iran. And let me find that in my brief, Your Honor. I apologize. JA 774, pages 9 through 14. I'm sorry, that's actually the Court of Appeal, I mean, the Superior Court, where Judge Pan found the facts that the waive agreement, the waive proposal, and the work plan all contemplated travel to Iran by IJMA 3, and that Palladium would not travel to Iran. So that is a finding of fact that Judge Pan made below. And I apologize, Your Honor, if I may, I'll try to find exactly where that is in the agreements. JA 104 and 128 at page 11 of our brief, Your Honor, we say all travel to Iran will be undertaken by regional partner staff. Both agreements specifically contemplate that IJMA 3 personnel would travel to Iran. That's at JA 104 and 128.
Right, and I read that as Futures Group won't travel to Iran, but not that anyone is required to travel to Iran.
Again, Your Honor, it is contemplated, but as in most government contracts, there's nothing that says you must do this. So this is carrying forth policy activity that the State Department wants to conduct in Iran. They want to promote women's issues. So they don't require a specific action, but you can see from the contracts that they are substantially involved in every aspect of work that Palladium does here. The travel to Iran, the who,
Well,
what, why, when, and where must
I'll
be
press you
set
on
forth.
this a little bit. When you say that they were substantially involved, how do you interpret the language? This travel is not required under the terms of the project, but is undertaken at the organizations, which is St. Palladium's, and travelers' own risk. How is that a direction to do anything?
So again, it's the question is it a requirement? So direction here in my client's view does not mean that it's required. What we look for under the contract, as you pointed out in Yearsley, the government doesn't have to authorize every scoop of sand that's made in the river. And so here, what we have authorized and directed is a plan, is a contract, is an agreement that specifically contemplates that Mr. ZAKKA is going to travel to Iran.
That's true.
Yes.
The government contracts with, here it's a grant, which is a little bit different, but let's ignore that distinction. The government contracts with an entity, please transport. We want you, we direct you to transport X across the country to the West Coast. We have a telescope here on the East Coast. We want to launch it in the West, up into the air, and on the West Coast, we're hiring, Atlas van lines to transport this telescope across the country. We direct you to do that. Maybe we'll tell you even what route to take. And yeah, we want you to do it in a certain amount of time and so forth. It seems to me odd to think that if Atlas takes on that assignment and its driver is completely negligent and causes an accident that causes a great deal of damage on the way, that Atlas could say, well, we have sovereign immunity derivatively because we were carrying out the government's request to transport this across the country. The government didn't tell it to act. The government left many things to the discretion. And that's what happened here, it seems to me. The government left many things to the discretion of Palladium, even assuming that it directed Palladium or authorized and directed Palladium to send people to Iran. And that's I think gets to the nub of the problem that I have with your argument here. The case law seems to indicate that there is a degree of granularity, to use the word that's been used before, that basically the immunity is a narrow immunity that a company has. If the government directs it to do something and doing that thing basically gets the company in trouble, it can say, look, we did what the government told us to do, and you can't sue us for doing that. But that doesn't mean that if you do something the government didn't tell you to do, if you did what the government told you to do in a completely negligent fashion, or, you know, there's a range of variations there. I don't see that you can claim that you were directed to it, that you just stand in the shoes of the government in that way. How do you respond to that?
Well, Your Honor, again, I think if you look at the email, it says the travel is authorized, and then it directs the manner in which the travel is going to happen. So what the court says in that email is that travel authorization is granted, and then it gives several directions as to how that travel is going to be conducted.
Which directions are you referring to that have a bearing here?
The travelers will be traveling with documents issued by the respective governments, none of which are the U.S. government.
Well, let me, I'm sorry to interrupt, but let me just tweak Judge Glickman's hypothetical a little bit. Let's say the same thing is true. This, transport this thing across the country. And there are directions, use the I-10, make sure you find a licensed driver, somebody with 10 years of experience, et cetera, et cetera. And they say, got it, we're going to comply with those directions. They go down to the local drinking hole and they find the drunkest guy they can find and say, you, sir, any DUIs? Yep, have a bunch of them. They say, okay, but do you have 10 years of experience? I do. Okay, well, take I-10 West, take this thing and off you go. Do you think that they're going to have derivative sovereign immunity for, a suit that says you shouldn't have hired a drunk man with 10 DUIs on his record, even though there were directions that guided that trip, and even though they complied with those directions? It's something that is not contemplated by the directions that are given. Like, what's your reaction to that hypothetical, and why doesn't it look sort of like the case here?
Well, Your Honor, my reaction to the hypothetical is it has to be authorized and directed, and you can't deviate or exceed those standards. And what I would say
I guess in my hypothetical example, the directions don't say, don't go find a guy who has 10 DUIs on his record. They're silent as to the DUI. They left that to the determination of the carrying company.
Your Honor, in my mind, that case would end up having some sort of factor that meant that hiring a drunk person deviated or exceeded from the expectations that the government had when it hired you and directed you to have this travel. So,
but none that are specified. So you think there's some reason, because the government could reasonably expect that company not to do something like that, which just sounds like you're in negligence territory, which sounds to me like what Mr. Zakka's claim is. The government reasonably would have expected them to provide security measures along the line, even though it's not in the directions, along the lines that they kind of suggested they would do in their application. And the government could reasonably expect them not to keep their subcontractors in the dark about Palladium's standing in Iran and the dangers that could befall them. Sounds similar. So let me get to the second part of my question. Why is it not similar to this case?
Well, in this case, if you look at the contracts and what they say about risks and constraints, it's all talking about how Palladium is not going to go in country. And instead, we're going to rely on the expertise of IJMA 3 and Mr. Zakka when he goes into the country. And I do want to point out that, as Judge Pan noted, the email authorizing the travel also had directions about security procedures. It said it does not supersede travel warnings issued by the US government for the destination country. So you need to go there and look at the travel warnings. And all of these conditions were met.
This just sounds like a very different theory than what the trial court adopted. If the theory is this, Palladium was entitled to rely on IJMA 3's own expertise, and they're the ones who failed at this. That I get. But that's not a derivative sovereign immunity type claim. I assume you raised that defense below and it hasn't been ruled upon, right?
That
Something like that?
That's correct. We discussed that, yes, Your Honor. But we didn't get to that point because
Right.
of the sovereign immunity issue.
Yeah, so I just guess I don't see how it affects the sovereign immunity question. Yeah, it might be that you can pass the buck on downward. But it doesn't tell me why you can pass it upward to somebody who didn't direct the type of malfeasance that's being alleged.
Well, again, Your Honor, I think what Yearsley and Campbell Ewald tell us is that this shield from suit, this immunity from suit that we believe derivative sovereign immunity is that what's critical in these cases is, did you follow all the government's authorization and direction? And here we have no allegation that we deviated from any of those
That sort of says
authorizations.
it too shortly, though. Did you follow all the government's directions? That's only relevant if the government directed you to do something that is now alleged to expose you to liability. So, the government could say, well, when you fly to Iran, fly, a US chartered plane or fly some other countries.
That was part of it.
You say, well, I followed that direction. Well, that seems a little irrelevant to the question of whether you engaged a pilot who knew how to fly. Or when you were on the ground in Iran, you took the appropriate precautions. Where the government is silent about something, it's hard to see a direction. When you say, I have two questions about this. One is, when you say that direction does not mean required, it sounds like you're equating direction with permission. The government permits you to do something. That's not the same thing as directing you to do something. The word directing seems to say you do it this way, or you do it under these conditions and requirements. And that seems to be, what's lacking here. When the government instead says, Palladium, if you do this, you do it at your own risk. What does it mean to say to Palladium, you're doing something at your own risk?
Your Honor, my suggestion is that has nothing to do with authorization or direction or Yearsley immunity. I think she's trying to absolve the State Department.
It sounds to me like it's saying we're allowing you to do this, but we're not directing you to do this. And if you do it, don't come to us, or don't rely on us.
The State Department,
You're
yes.
taking you're doing this at your own risk. It sounds like a disavowal of any sort of derivative sovereign immunity.
Well, I would disagree. I mean, perhaps it's an assertion of sovereign immunity that, this is at your own risk.
It's an assertion of the State Department's sovereign immunity.
Correct.
Well, it's not really, it's consistent with the State Department's
I think so.
assertion of sovereign immunity, but it's not clear that gets, if you come to me and you say, gee, you're a judge, I'm working for you. Can I go across the street and get you a sandwich? I say, well, you do it at your own risk. It's hard to see that you have judicial immunity.
I understand your point, Your Honor. I did want to point out that when you were talking about direction just a moment ago, you said, that's where the government says to do it this way. And of course, they did tell us to do it this way. They told us how to travel. So there's a lot of conditions and directions within that email as to how you should conduct yourself when you travel to Iran. So as we talked about before, it's granularity. You have to get into these cases. I think everybody would agree with that they're fact-based. Judge Pan did conduct factual discovery here. The documents are what's important in this case, the email and the agreements and what they say. They show that the State Department has substantial involvement over every action that Palladium took in this case. The appellant's argument that there's a lot of discretion in these contracts is absolutely shown to be wrong when the agreements are looked at. Again, the monitoring and evaluation.
I'm sorry to cut you off already, but I'm just looking at Judge Pan's ruling. It's at page 4 of the transcript. And this is really all over the transcript. You say there's sort of a factual finding as to direction, and I don't think there is, because what Judge Pan says is we're down to whether the factual issue of whether the travel by Mr. ZAKKA to Iran was authorized by the State Department. And she sticks to authorized, and everything about her analysis to me seems like she is disavowing a direction requirement that you now seem to be acknowledging exists. Now maybe it's just down to semantics. Maybe you're going to tell me, well, I'm reading too much into the semantics, and really she was baking a direction type analysis into her authorization inquiry. Is that your answer?
I could not have said it better myself, Your Honor.
I mean, I just say, it is conspicuously missing from her conception of the inquiry. And unless you want to point me to a part in the record where it seems like she considered direction.
Well, again, I think it's the phrase is authorized and directed, so it's all baked in together. I don't have a cite to you where she might have said the
I don't
word
think she
direction.
recognizes that phrase. I think she's disavowing that.
But again, our position in this case, or the appellant's position in this case, is that directed means required. And I think that narrows
let me
years.
stop you right there, because I agree with you that direction means required. So then you look at JA 472, this travel is not required under the terms of the project. So that to me seems, if we think required and directed are the same thing, this travel is not directed.
And I would disagree with Your Honor that direction means required. I think that too narrowly makes the Yearsley standard much too narrow
So you
to
no longer
solve
think-
its policy.
You no longer
concerns.
think directed means required.
I never said that. If you thought I said that, I apologize, Your Honor.
If
I said
directed-
direction did not mean
Directed.
required.
When you say directed does not mean required, what does directed mean?
So in this particular situation, the travel was authorized and the Palladium was directed to follow these particular conditions in order to take that travel. And there is no allegation in this case that we did not comply with any of those directions. In fact, we did comply with all of the directions.
Well, so the example you've given is an example where directed means required. But you're telling me directed doesn't mean required. What does directed? Put aside for a moment the facts of this case. How do you define directed as the Supreme Court and the courts of appeals have used it in talking about this derivative immunity doctrine?
So authorized and directed, you look at whether the.
Directed must mean something more than authorized, because otherwise we'd just be saying authorized and
Right.
authorized. Okay.
Did you follow the authorizations? Did you follow what you were directed to do? So the authorization, was it followed? And this authorization contained directions.
What
So-
does directed mean in your view? Does it mean required? You say no. What does it mean?
What did the,
Allowed? Does it simply mean allowed?
I think it means what did the government tell you to do when taking this action?
So in other words, if the government tells you to do, suppose the government says, well, we'd like you to do this, but you don't have to. It's just what we would like. Is that a directive? Is that direction?
Well, if they went on and they said, we think you should travel to Montana and that's proposed and that's in the agreement. And then the government says, well, if you're going to travel to Montana, then you need to travel in this manner.
Need to. So need to is required. I mean.
Well, need is not the same as required. And I would suggest that under these
If you need
agreements,
to do something, I would have said that's required. You're required to do it.
I think they're two different
No.
words, Your Honor, that
Well,
don't mean
they
the same
are.
thing.
They are two different words. In
Yeah.
what way? What
I mean, these agreements show the need to go to Iran. So that's what I would say. If you look at these agreements closely, they're all contemplating that we're going to go to Iran. We're going to put boots on the ground. We're going to.
And your view is that if they were directed to go to Iran, then anything that happened on that trip, however attributable it is to the negligence of the Palladium, or it could be worse than negligence, but let's just stick with negligence. Palladium has immunity defense too?
Yeah, there's strong policy reasons, Your Honor, to avoid the kind of second guessing that a case like this entails in the government's decisions on how to conduct its foreign policy.
Although it's interesting that the government does not think that this is a jurisdictional question. That's one point against, do you want to address that? You would think if the Fourth Circuit were right and they invoke all the governmental interests that are at stake in finding this jurisdictional rather than an affirmative defense, well, you'd expect the United States to say, yep, we sure do have an interest in that. And instead, we have the United States disavowing this as a and I know I'm kind of pivoting from the merits a little bit, but I did want to get your take. It seems to me like we ought to find the United States position on this as to whether or not it needs to be jurisdictional as a policy matter, extremely persuasive, that we should give it a lot of credence as to what it needs its immunity to extend to. So why wouldn't we take, I understand the United States in Casey to have said, CACI, to have said this is not a jurisdictional thing that our contractors get to claim. It's an affirmative defense. Why shouldn't we give that a whole lot of weight?
Well, Your Honor, because the Supreme Court has actually said exactly the opposite. So in the Campbell-Ewald case, it frames the issues as we set forth in our brief as immunity from suit, shield from suit. So everything that Judge Ginsburg said in the Campbell-Ewald case characterized this defense as one that derives from the sovereign, which was recognized.
I don't think that's what those words mean. We have anti-SLAPP cases all the time, these First Amendment cases. That's a legislative immunity from suit. It gets through discovery. It's not a jurisdictional question. I don't think these are magic words that only apply to jurisdictional questions. I can
Qualified immunity is an immunity from suit, but it's not jurisdictional.
Right. And it actually derives not from sovereign immunity, but from a preemption analysis, Your Honor. So I think there's two different routes between Yearsley and this qualified immunity that would put Yearsley on the immunity, the shield from suit, the jurisdictional basis, whereas the qualified immunity comes from a preemption analysis. And that's why it's an affirmative defense. I would say, Your Honor, in regard to that position of the federal government, that's in a brief that they filed in the case. And so we know administrations change. So I don't know the exact date of that.
It was in the Trump administration.
Yeah.
It was a Jeff Wall brief, and I believe it postdated Campbell. I think it was a 2018 brief, which would postdate Campbell by a couple of years.
Yeah. So the administration's positions can change. I don't know what their position is today.
Okay.
In Campbell-Ewald, there was a motion, I think, for summary judgment that was being, in which this issue was raised. It was not a 12B1 motion.
That's correct, Your Honor.
One thing that I was going to ask you, and you've touched on it, I'm not sure I caught everything you said about it, is whether you think that the claim of derivative immunity is like a claim of qualified immunity for purposes of whether we think of it as jurisdictional or.
Do I think I think they're alike or different? Is that the question?
Yeah, my reaction tends to be to think that just as that a claim of derivative sovereign immunity, these are just labels. The question is to get to the substance. Such a claim is comparable to a claim of qualified immunity, which I take it generally be treated as non-jurisdictional.
That's correct.
There may be exceptions, but
that's what the case law says, Your Honor.
Right.
But they are very different, the considerations.
But I wonder, tell me why you think they're so different.
Yes.
Absolute immunity would be jurisdictional.
Understood.
Person who has qualified immunity or the entity that has qualified immunity says, well, we because of we essentially hop onto that absolute immunity because we meet certain various requirements, whatever they are, for the particular qualified immunity involved. And so there does seem to be sort of an analogy here between the absolute sovereign immunity of the United States and the sovereign immunity of some private company that normally can be held into court without any problem for its negligence or whatever. Which says, well, but because of this peculiar relationship we had with the government, peculiar meaning particular relationship we had with the government, we have a defense to liability, and that we'll call that defense derivative immunity, because we were doing the government's bidding in some sense, and you can't hold us liable for that. Okay, well, that's a very fact-dependent thing. And it sounds like a more an affirmative defense that an otherwise liable party would have, rather than a jurisdictional limitation. It sounds like qualified immunity. Why do you think it should be treated differently?
Well, again, Your Honor, because as you've noted, it derives from the sovereign's immunity. So it comes directly from something that we all agree is jurisdictional. So there would be some reason that you would need to cleave this off and say it's not jurisdictional, it should be a qualified I'm sorry, it should be an affirmative defense. And there really is no reason to do that. The policy reasons behind derivative sovereign immunity, which is to allow contractors to avoid the distraction of a lawsuit, to not be timid about the work that they take on, to get the best candidates. Those all would make having this decided at the beginning of the litigation the most preferable way to handle derivative sovereign immunity, just like you handle sovereign
deciding
immunity.
at the beginning is one thing. That's that, you know, certainly good for the contractors, but you know, the question is whether the usual rules of letting a case go to the jury if a reasonable party could, you know, in other words, it's really a question of who's going to be the fact finder here on this issue. Should there may be some other questions as well, but who's going to be the fact finder? Is it going to be the judge or is it going to be the jury? And I wonder whether it should be the judge in a case like this, where it's so fact dependent. And where in general, if a claim is one of qualified immunity, it's the jury in principle.
Yes, Your Honor. Well, again, because it derives from sovereign immunity, I think judges are actually more well equipped to handle these jurisdictional type questions than a jury is. So I would advocate for the judge to always decide issues like this. And I'm not trying to play favorites here, but
Can I ask a follow-up question? So
Yes.
let's say we agree with you that it is jurisdictional because it's derivative sovereign immunity, and sovereign immunity is jurisdictional. And we find that you don't meet the Yearsley test here. So then we send this back and the question of immunity would fall out of the equation entirely, because at that point you wouldn't be entitled to it as a merits defense either, correct?
I think it would, when you say we're not entitled to Yearsley immunity, it would depend on what you said in that regard.
So what if we said this was authorized, not directed, so no immunity?
So I guess we could go back and try to find the kind of directions that you tell us we need. So it still could potentially come back. But again, I think we have done adequate discovery and looked at all the documents. And I don't think there are any further directions out there that we could rely on. So I think it would be unlikely that this would come back on an immunity defense. There are several other defenses as well, but we, again, believe this is the strongest one. And back to your question, Your Honor, about the qualified immunity. As we know, here we've got somebody stepping into the shoes of the government, so to speak. The contractor steps into the shoes and does what the government wants. And the questions that Yearsley clearly tells us to ask are, was the authority validly conferred? Was it authorized and directed? Did they deviate or exceed that authority? Those are clear questions that you have to answer. And with the qualified immunity case, though, that I think that you're referring to, the questions are much different. We look at the plaintiff's allegations. Are they alleging that there's some federal or constitutional right that was violated? And is it a well-established right? And so the questions on qualified immunity involve completely different factual situation and inquiry than we have here in the Yearsley case. So again, I think that's why I think the two are different.
Okay,
I've far exceeded my time. Thank you so much, Your Honor.
thank you.
We do hope you'll rule in favor of the appellees in this case.
And Mr. Farrar, we'll give you a few minutes in rebuttal.
Thank you, Your Honor. Just a couple of points. Judge Ali Khan, at the outset, you asked where in the record is there any indication of travel to Iran? Mr. Boyd cited JA, I think 104. And I think the answer to that, though, is misreading that provision. The cooperative agreement discusses in-country activities. Mr. Zakka's declaration at JA 609 explains what that means. And what it means is that Iranian civil society organizations needed to be contacted, and that even those organizations were, which they were, flown out to Beirut to meet with Mr. Zakka and members of Palladium, by the way, in order to train them. And then they would go back to Iran and they would train other Iranian organizations. So, don't interpret in-country coordination to mean travel to Iran. Judge Glickman, you asked your question, a hypothetical about Atlas and the van, et cetera. I think this is actually a clearer case, because it would be as if Atlas is pitching to get this award, and they're saying, we're the best in class. We've got an app that's going to avoid all of the ways to get there, all of the terrible traffic so that we won't get into car accidents. Also, we're going to sub drivers out so that one guy doesn't get tired while the other lady steps in, et cetera, et cetera. And then they get the contract awarded and, they get the money and they're like, yeah, we didn't do any of that stuff. And then the question is like, well, then like, what were all those representations about? Now, it may be that those representations don't matter in this case. I don't know that because there wasn't any discovery allowed on that particular issue. Judge Deal, you modified Judge Glickman's hypothetical to be like, well, what if, it was a DUI? That was sort of the fact pattern. Under their version of the law, all state law is gone. It goes out the window. It's entirely preempted by a contract. Even violations of state criminal law under their interpretation of the law would go out the window, and it wouldn't matter. It'd be totally preempted. Which is ironic because the one case we keep citing about preemption, Boyle, has a very stringent standard for what needs to be met. And they keep distancing themselves from Boyle and saying, this isn't a Boyle case. This isn't a preemption case. Well, you can't have it both ways. You can't have all the benefits of Boyle and none of its stringent requirements. Judge Glickman, you kept, pressing, like, what does own risk mean? What does own risk mean?
Sorry, I don't think I understood that, because I understood Boyle and military immunity to be deriving from the United States government's sort of sole monopoly on the means of force in the military. And so this is coming from sovereign immunity, not from kind of preemption.
Right. I agree with you. I think they are related, but not coming from the exact same place. But my point is that if they want to go for this argument that the government contract preempts all state tort law, all state criminal law, all state law, period, there is a path for that argument. It's Boyle, but they're saying they don't want to assert Boyle because Boyle has these highly stringent requirements as reasonably precise specifications. They have to comply with those precise specifications. They have to warn the US government about what the risks are that are latent, that aren't being told, that the federal government isn't aware of. So that's my point. It's just like, you can't kind of like have your cake and eat it too. Own risk, what does that mean? One day I would love to ask the State Department what own risks mean, but in the joint appendix, we have Ms. Alami's declaration, and she says after Mr. Zakka was abducted, that her and Mr. Abel were called to the State Department, and they kept pointing to the email being like, we told you were proceeding at your own risk. What does that mean? I think it means something. And at some point in discovery, we're going to find out. There's also, by the way, an email from an earlier trip to Iran in the JA under the predecessor to Palladium, IRD. That language doesn't appear in the approval email. So the inclusion of it has to mean something. It's not just meaningless boilerplate or the State Department reminding everybody that it can't be sued because it has sovereign immunity. I think that's all I need to say. Thank you very much.
Counsel, thank you both. The case is submitted.
All right. This court is now adjourned.